We're on the record.
Okay, call the meeting of San Francisco Sunshine Ordinance Task Force to order, 4:01 p.m. Please call the roll.
On the call, the roll. Member Eldon. Present. Eldon present. Josh Wolf, absent. Copra, absent. Member Tesfa. Here. Tesfa present. Member Moss.
Present.
Moss present. Member Kanata.
Here.
Kanata present. Member Fisher. Fisher absent. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland.
Present.
Hyland present. Chair Wolf.
Present.
Wolf present. We have a quorum. There are no agenda changes that I know of at this time.
Members, any changes to the agenda? Okay. Hold on a minute. Call the next item.
Next on the agenda, item number 2, approval of the minutes from the Sunshine Ordinance Task Force September 6, 2017 meeting.
Through the chair.
Yes.
Okay, so I noticed on page 5 when we're summarizing comments from the I guess it's the Clark order. Anyways, it's on page 5, and I noticed that one of the summaries of public comments said male speaker provided general comments regarding the matter. And I was just hoping that maybe we could get some more specificity than just general comments, considering the ordinance requires more of a summary. And that was just I just sort of noticed that going through.
What would you like to see?
I have no idea what the person said.
I do the best I can. However, there are many times where I just can't decipher it, and that's the only time I use general comments.
Yeah. I think if it's unintelligible or whatnot, maybe something to that account might make more sense than just saying general comments.
So, like, put in parentheses, unintelligible?
That's fine to me.
Okay.
If there's even like one point, or they say general comments about, et cetera, or if it's able to tell who he's in support or opposition of, or what have you, I just want to make sure that we don't end up getting, like, somebody comes in and says, hey, my comments weren't summarized, I'd like to make a violation against the Sunshine Task Force. I think we've gotten similar complaints from other entities, and so whatever we can do. I just noticed it in there. Take
Note of that. Victor, thank you.
Yes.
Any other changes, adjustments to the minutes? Is there a motion?
I'll move to approve the minutes.
Second.
Moved by Member Moss, second by Member Hinsey. Is there any public comment? Seeing no public comment, can we take this by acclamation? Seeing no objection.
That motion passes with Member with Member Wolf, Josh Wolf, Member Copra, and Member Fisher being absent.
Yeah, great. Let's recognize Member Fisher at 4:05.
Next on the agenda,
Yes.
item number 3, file number 17083, complaint filed by Michael Petralis against the Police Commission for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Are both parties here?
I do not believe that Mr. Petralis is in the room at this time.
Okay. Members, shall we proceed? There's no requirement for both parties to be at the main hearing.
We do ask that they appear. I believe that is generally what we ask.
Okay.
When they are noticed, they are both asked that they appear.
Okay.
Through the chair, I think we changed it to both pre and full meeting. I was
Have both?
Yeah,
Okay.
I was mistaken too, but we went back and looked at our procedures and we decided for both.
Okay.
Through the chair, perhaps was there agreement that parties were in violation and they didn't have to appear, or?
I think the only time that there was no requirement to appear was if there was no disagreement on
I was wondering if that
a violation.
might be the case in this.
Right.
Through the chair, can I?
Yeah.
Since this was our committee and I Per your request, I actually did study it and go through my notes.
Okay, good.
I'm actually kind of surprised that the complainant is not here because we forwarded this on, if you were there with me too, we forwarded this on because we had no recommendation because we looked at it as, we don't really think this is a violation. I think we had one or two questions for the city attorney. And I specifically remember saying, yeah, there's a little bit in here, but it's an overreach. It's an awful lot of information. So that's why we did not see any violation. So it could be why he's not here.
All right, so how do you want to proceed, with or without the complainant? We can do that.
Through the chair?
Yeah.
Has any new information been provided to Victor since that last committee meeting?
I believe that there was some movement in that the committee suggested that Mr. Petrellis contact the police commission to ask them regarding what to release the document. The police commission heard the matter and they reported back. It's in your packet. And maybe we can ask the police commission to provide an update on that.
So I'm going to suggest that we move forward with the case. If we find sometime at some point in the middle that the complainant, the petitioner should be here, then we can, deal with it then. Table, postpone, continue, whatever, at that point, okay? All right, let's move ahead. So the petitioner is not here. Any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none. Respondent? You have 5 minutes to present.
Hello, good afternoon. On June 19, 2017, the Police Commission received the immediate disclosure request.
State your name, please.
This is Sergeant Angela Rodriguez. I work for San Francisco Police Department and the Police Commission. On June 19, 2017, the Police Commission received the immediate disclosure request for copies or access to audio or video recordings of all Commission closed-door sessions from January 1st through May 31st, 2015. I responded to Mr. Petrellis on June 20th that per Administrative Code 67.25a, this was not a simple or routine request, therefore did not fall under the parameters of an immediate disclosure request, and that the normal timelines would apply to the request, which is 10 days. On June 23rd, Mr. Petrellis inquired if I was still working on his request, and I responded that I was. On June 28th, pursuant to Government Code Section 6253C, I sent a letter to Mr. Petrellis regarding the request for an extension with notice that we would respond no later than July 11th, 2017. On July 5th, 2017, after getting direction from the city attorney, I sent a final response letter to Mr. Petrellis. All of the items in the closed session of the Police Commission meetings between January 1st and May 31st, 2015 included discipline, personnel issues, evaluation, hiring and appointing, and existing litigation. In summary, the letter explained to Mr. Petrellis the following. We declined to disclose audio recording and documents associated with the closed sessions involving personnel matters. Regarding the closed session evaluation of the chief, this matter included evaluation of his performance, which is considered a personnel matter. Therefore, no recording or documents were disclosed. Regarding the closed sessions for peace officer disciplinary proceedings, the disciplinary proceedings are confidential under Penal Code Section 832.7. The California Supreme Court has held that Section 832.7 mandates the confidentiality of all records of peace officer disciplinary proceedings. And although the Sunshine Ordinance requires the Commission to release closed session recordings, whenever all rationales for closing the session are no longer applicable, the peace officer disciplinary proceedings must remain confidential based on California Penal Code Section 832.7 and find that the rationale for these closed sessions remain applicable. As well, the Commission met regarding pending litigation for 2 cases. These closed sessions discussions were for the purpose of discussing existing litigation with counsel and is subject to the attorney-client privilege and is exempt from the disclosure under the California Public Records Act. For the foregoing reasons, We declined to disclose the audio recording and documents of the 2 closed sessions for pending litigation. On August 15, 2017, I attended a hearing by the Education Outreach and Training Committee of the Sunshine Ordinance Task Force. The task force implied its understanding and recognition of the Commission's authority to decline the release of the audio recordings of closed session matters regarding peace officer discipline and peace officer personnel matters under California Penal Section 832.7. As for the litigation matters held in closed session, excuse me, the task force recommended to Mr. Petrellis that he request the Commission place an item on the Police Commission's agenda for a vote to waive the attorney-client privilege for audio or video recordings of Police Commission closed sessions from January 1st to May 31st, 2015. On August 16th, 2017, the Commission received Mr. Petrellis' request to place an item on the Commission agenda regarding a discussion and possible vote for the Commissioners to waive the attorney-client privilege for items held in closed session from January 1st, 2015 to May 31st, 2015. The Police Commission placed this item on its September 20th, 2017 agenda and voted 4-1 not to waive the attorney-client privilege for audio or video recordings of Police Commission closed sessions from January 1st, 2015 to May 31st, 2015. And Resolution 17-49 was adopted September 20, 2017, included in your packets. For the foregoing reasons, we again declined to disclose the audio recordings and documents of the 2 closed sessions for pending litigation, as the Commissioners have voted not to waive the attorney-client privilege for these matters and continue to assert the attorney-client privilege in these matters. The Commission also reaffirms its reasons for not disclosing the audio recordings related to peace officer discipline matters and peace officer personnel matters.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none. Members. It's now we're for questions and clarifications. So I have a question.
Yes, sir.
Sergeant Rodriguez. You stated in your opening that, first of all, this was an immediate disclosure request,
Yes.
and that because of the information that was being asked for, that you decided that it wasn't an IDR.
Correct.
How did you come to that conclusion?
Because I would have had to go back to 2015 and look at all the agendas and go through it, and I wouldn't be able to provide the information in a timely manner for an immediate disclosure request.
And where in the ordinance does it allow you to convert an IDR into a regular request?
It is in the Good Government Guide, I believe, that shows the time frames of immediate disclosure request and then what an extension is.
Okay, so to avoid some confusion, we've had this situation many times, and we have determined that no one can convert an IDR into a regular request. An IDR is an IDR as it's presented. If it's voluminous, or you're required to contact other agencies to get information. However it is, you need an extension of time. The extension is 10 days. And an IDR exists as long as the item kind of survives. So you can provide additional records on a rolling and incremental basis as they arise. But we have found and hold that IDRs cannot be converted by anyone to a regular request. So just for your own edification and for the department, we'd appreciate if you would transmit that to them. We have ruled on that several times.
Okay, thank you.
I want to move to Penal Code Section 832.7, which you cited as a reason for withholding the information. Was Mr. Is Mr. Petrellis a complaining party with regards to what is being asked for with regards to the personnel information?
He's not a complaining party. He's asking for the information to be released, and it's protected.
Okay,
by
so I'm
832.7.
reading through this particular section, and it speaks specifically to, in A, 832.7A, it states that the records should not be, are to be maintained as confidential and should not be disclosed in any criminal or civil proceeding. That's in A. In B, it states that the department or the agency shall release to the complaining party a copy of his or her own statements at the time the complaint is filed. This seems to be information regarding, an actual complaint, not necessarily something in relation to in a meeting, a public meeting. And a closed session is a public meeting, it's just closed at the time.
Well,
So-
I was guided by the city attorney
Okay.
to answer in this.
All right. Well,
way.
that's problematic for us because the city attorney should not be providing you with information to help you withhold information. The ordinance is pretty clear about that. Can you provide me with some of the other sections of law that you cited? Provide us.
Let's see. Government Code 6253C.
6253C. That's also in the penal code?
No, there was no penal code. It was the administrative code, the government code section regarding the IDR.
625 point, wait a minute.
6253.
53C. Oh, just
Yes.
okay. That's, for the CPRA.
Yeah.
Okay. Got it. Okay.
Bless you.
Thank you.
I just quoted on 832.7.
Got it. Anybody else have questions? All right, just a moment. Come on, internet. No, it's not. Oh, that is not listed. Government code. Government code? It's 6253. There's 7.3. Got it.
Through the chair.
Yes.
Can I just make sure I understand just the sort of a fact here? So it seems like that there were 5 matters that came up in a closed session. Was it an evaluation of the chief of police, 2 separate disciplinary matters involving police officers, and then 2 litigation claims? So for a total of 5?
There were all of the discipline matters are not quoted on here because they all fall under 832.7. There were 2 matters with the chief,
2 matters.
and then there were 2 one matter with the chief, and there was 2 litigation matters.
Okay. I'm just looking at the letter that you sent to us, and it refers to the commission also met in closed session on March 11th for 2 peace officer disciplinary matters, and then it gives case numbers. So I just wanted to make
Those
sure.
are the litigation matters.
What's that?
Those were the litigation
Those are the
matters.
litigation. Oh, because it seems like elsewhere it says during January they also met in closed session about pending litigation. So those are what you're saying is that there were only 3 matters then. and that
Correct.
the disciplinary matters were both cases in which. Okay, I understand. So there was three matters. Thank you.
Mm-hmm.
'Cause, 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 'cause
Sergeant Rodriguez, are you familiar with Sunshine Ordinance? It's the Administrative Code 67.24.
This is my first time coming before you, and the
Okay.
first time I'm asking,
All right, it's just,
answering. apparently,
it
but-
lists what should be disclosed with regards to personnel information. And
Can you-
usually when law enforcement comes before us and they cite they wish to withhold or they have withhold or decided to withhold, it's usually based upon something that's in investigation. So they couldn't withhold the information because it's involved. It's an investigation still open, or a case is still being reviewed and not closed and ready to be. Its status isn't marked public yet, or it won't be for that reason. So I'm just looking at 67 for the members here, 67.24 C. So if you have your ordinance in front of you, you might want to take a look at that. Vice Chair Hyland.
Through the chair, I was on that same vein. I was going to ask any of our lawyers or the DCA, are there statutes of limitations that expire? Are there, when a case that was open in 2015 is since closed, does that then make it a public record? I'm just curious.
Good question.
It does.
If that's your question.
Basically, yeah. Okay. That goes all the way down to personnel records.
I was talking about attorney-client privilege. So I was talking about attorney-client privilege, which is what the officer mentioned.
I'm just looking at the actual request and seeing whether it's...
Yeah, but this case does not involve attorney-client privilege.
They said there was litigation that they were discussing in closed session.
Correct.
Oh,
Part of it was that.
Right, there's two.
It's two-pronged. There's the discipline, and then there's the litigation. And so the litigation, because it's the attorney-client privilege, the commissioners voted again to not release any information.
DC Acola? So where is attorney-client privilege protected in regards to a public meeting? Is that in court procedure? Is there a specific law that protects?
No, any aspect of it. I mean, if there's a commission, for example, there's pending litigation with the police department, and the police commission wants an update on a litigation between the city and some other party that's suing the city because of police conduct allegedly. Mm-hmm. Well, the commission is entitled to have a closed session hearing so they could discuss the merits of that case. If it was open to the general public, then opposing counsel would be privy to all that information that they normally wouldn't have.
Okay, so this is regarding section 6724B under litigation material?
Yes.
Okay, thank you.
I think it would also be under 67.10B. Is that what you just said?
6724.
Okay, I think under
B.
67.10B, we need to consider there that this is a specifically permitted topic for closed session.
Mm-hmm.
So that I was also looking at it through that lens.
Yeah, I don't.
There are multiple.
Yeah, I don't think that we're objecting that it's not appropriate to discuss in closed session because it's a personnel matter. The question is what is supposed to be disclosed, and that's where it's 6724 B comes into play. It does state in 67.24B 1(2) or Roman numeral 2, a record previously received or created by a department in the ordinary course of business that was not attorney-client privilege when it was previously received or created. police department's holding that this was still maintained as attorney-client privilege. So that would not apply if that's where the petitioner was looking for to get the release.
It doesn't sound like it. That's what the petitioner looking for to get the release.
No. Okay. All right. I have nothing else. Anybody else?
Just through the
Yep.
chair. Sergeant Rodriguez, just curious as to why you invoked an extension if you never really intended on releasing any documents.
I didn't never intend to. I had to go through the process. It was my first PRA. And
Okay.
I had to.
Fair enough.
Anybody else? Should we move to rebuttals? Okay. Sergeant Rodriguez, don't leave yet. If you have it, you have 3 minutes for rebuttal. If there's anything further you would like to express, this is your time.
No, thank you.
Okay, thank you. Petitioner is still not present. Okay, members, what shall we?
I'd like to make a motion. I'd like to make a motion to not find violation.
Second.
Moved by member Tesfaye, second by member Fisher. Is there any discussion on the matter? Is there any public comment on the matter? Seeing no public comment, please call roll.
On that motion, Member Eldon. Aye. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Please call next item.
Next on the agenda, item number 4, file number 17071, complaint filed by Michael Petrellis against Supervisor Jeff Sheehy, Board of Supervisors for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and or complete manner. I don't believe that either party is present today. However, we did hear this at our last Sunshine Ordinance Task Force meeting, and we continued it. We did take a vote on it.
We continued it.
They took an initial vote before continuing it, and they decided to continue it to allow for a full membership to, as there was only 6 members left at that time, they continued it to today's meeting to allow for additional members to be able to chime in on it. Mm-hmm. I believe there is a summary from the minutes previously, if you would like to read about the previous discussion.
Mm-hmm. Okay, members. Go ahead, Member Hinsey.
If we took a vote on it previously, some of us that were here, we're not bound to the vote.
No.
You're not bound by previous.
No, the previous vote was to continue it to this meeting.
Through the chair, I seem to remember we took 2 votes, both failed 4-2.
Oh.
And then we
Right.
made a motion to continue it because we felt it wasn't getting its full hearing. I think that's my recollection.
Well, let me ask then. Some of us weren't here. I have reviewed the case somewhat. Would you want to adjudicate the case, having already heard the merits? The parties aren't here.
Through the chair, I think we should adjudicate it. I mean, I don't know what happened to Mr. Petrellis. He's normally here for his stuff, but the supervisor's office has never sent anybody.
Okay.
And I don't think they'll send, or did they at the?
They did at the complaint committee.
Okay.
They did.
Yeah.
Okay, first, yeah.
But I think we should go for it.
Well, I'll ask to. Well, okay. I mean,
Through the chair,
Yeah.
Vic, I'm having trouble pulling up the minutes because the internet's slow. Do you happen to have, maybe if we could review the 2 motions that were on the floor at the time, that might give us a starting, jumping off point as to where we got to. in the previous meeting. There was two issues, basically. We were two different sections that we found that were proposed as violations. That might be a...
This was 17071?
Yes.
17071. 75.
Through the chair.
Yes, sir.
So one thing I've noticed about the packet entry is that according to page 72, Mr. Petralis did receive records regarding his records request, and those records are not contained in the packet. And so it's kind of hard to have a full evaluation of the merits here without having those records to look at.
I can give some insight to help you. Mr. Petralis was requesting all of the calendar for Supervisor Sheehy from January 1st to the day that he was submitting the request. I think that was in June. Mr. Sheehy did not begin his supervisor role until after January 1st. He had served in some other capacities as a public servant prior to that date, so his office was trying to figure out, do we only have to provide the records that are from the date of his, I don't want to say appointment, but the date that, he was sworn into office to the date of the request, or do we need to also include his calendar from the time prior to that when he was still working in public service? I believe it was, he was on some type of a committee on stem cells, a state agency on stem cells or something. I can't remember what it was. But anyway, they were trying to figure out, at what point do they need to provide the records. So the IDR was submitted, and then the day after that, there was an extension. And then a few days after that, there was another extension. So we were looking at, were these extensions properly applied?
It sounds like people are interested.
More timeliness than completeness.
Okay,
Correct.
just as a matter of procedure, it sounds like there's some interest to move ahead with the case.
I think we can.
Am I getting that?
I've seen it twice now. Yeah. And further in the minutes, I can now see the two motions that we propose. We can review those and then kind of see where the full committee feels. But I don't think either party being here or not being here is going to really affect us at this point. I think all the merits are out in front of us.
Okay. Do I hear any objection to moving forward with this case? Seeing none. Okay, so we'll note for the record that neither parties are here. Are there any persons or witnesses to provide any additional facts or evidence on behalf of either party here? Seeing none. Okay, so the matter is with the task force now. I have a question. So with regards to the two motions that were made at the time, it seems that members Moss and Highland voted in the opposition for the first one, which was in failing to send a knowledgeable representative, and member Josh Wolf voted in the opposition
To the second one.
for the second one in failing to respond to the IDR.
In a timely manner. Yeah.
Right. So can maybe Member Moss and Vice Chair Highland explain a little bit more why they feel there wasn't a violation for the first part?
So I believe it was because of the first motion. There was one part of it that I agreed with, but one part I didn't. And I'm trying to sort out between the two which one it was. If you give me a moment, I can figure that out for you.
And as far as the second motion, while he's looking that up, I think.
Sorry.
Are you back? Okay.
Well, I mean, I think it's through process of elimination, seeing as I voted for just the 6725 in the second vote, that it must be the 67.21E that I was which is I believe it's the failure to send somebody.
Oh, that's right. Yeah, we had two sections, then we had one section. I got you. Okay, I see what you're saying. Yeah.
Yeah, one was sending a knowledgeable representative, and the other one was failing to respond to the immediate disclosure request.
I seem to remember that there was a knowledgeable representative at least one of the meetings. It might have been the subcommittee, I think, and that satisfied us, and they didn't come perhaps to the full meeting. I don't know, but the thing that actually Mr. Petros points out is that there were two extensions invoked, and that seemed unreasonable to us, which is why I proposed violation of 6725, which was
71.
timeliness. And I'm happy to make that motion again
707.
at the appropriate time.
Okay.
Through the chair?
Yes.
Okay, I can explain. So the reason I voted against the 6721E is that it was related to not sending an authorized representative. And by my reading of that, it says an authorized representative of the custodian of public records requested that request shall attend to any hearing and explain the basis for its decision to withhold the records requested. At the time that we had the hearing, there was no allegation that records had been withheld at that point. And so that is why I didn't feel like that part was appropriate. The records had all been provided, and there was no question about that at that point. And it was merely an issue of response time, not withholding.
Okay. All right. Member testify? Do you want to say something?
And I think that the reason some of us, at least I voted that there was a violation, was because the records had initially been withheld, and then for those two extensions. So I felt that that part did apply.
Okay.
Anyway.
Anybody else? All right. So then on the second part, with regards to, that's in a timely matter. Well, I don't. All right. So were they separated?
The first vote failed, and so there was another motion just to find a violation for timeliness.
Okay. And that
The
one.
vote was different,
Got it.
but it still failed
The quorum. So.
due to quorum
Quorum.
issues.
Got it. Okay. So
Let me propose the...
So seeing that there's no parties here for rebuttal, let's move to a motion on
Okay.
this.
So-
But let me. Okay, let's move to a motion. Go ahead.
So I was
Can I make one comment before
Sure.
we move to motion? I just want to state for the record that I think it's a bit unfair that we are taking extra votes for this matter because of lack of quorum issues. There was another item at that same meeting that also failed for the same reason, and I just don't think it's fair that this case is going to get the benefit that failed because we didn't have enough people. And I just don't think it's fair that this case is getting the benefit of that when the other one didn't.
Okay.
Yeah, but also at that meeting, we gave all of the petitioners an option of having,
Not for the first item that failed. That after that occurred, that was when we were like, oh, now we're seeing that because we don't have enough people here, it's very difficult to get a positive vote on an item.
think
And so
it's-
the rest of the items, the petitioners were given the option to have their item continued or something like that, so we could have more people here, and so that you would have so that if you had, it would require fewer votes.
To the chair, I think you're referring to item 3, the very first one we voted on, right?
Yes.
At that time, we actually had 7 people. That was our quorum. It later was reduced to 6. But yes, that's still a pretty slim quorum.
All right. So let me.
It doesn't matter here, I just wanted to state that.
Right.
Well, I mean, I think it's an important point to make. There's a significant distinction between noting and giving the option for all parties to request a continuance because of a voting threshold issue. And if one party was not afforded that, okay, then I think at that point they should be afforded the ability of a revote. If any, go ahead.
Just to clarify,
Victor. Yeah.
the parties were given the opportunity to state if they wish to continue or to not. Mr. Petrelis decided to go forward with the limited membership. And then after the discussion occurred and the vote occurred, then the committee took the vote to continue the matter after the fact.
Okay.
So items
But I was
5
saying
onwards.
the matter prior to that we didn't give that person the option. There was one less task force
Yes, that
member
is
there,
correct.
but the reason it didn't pass was because it would have required so many more votes, and we didn't have enough people here.
Yeah, items 3 and 4.
Yeah, and through the chair, that led to a discussion at the end of the hearing on possibly discussing changing the voting rules.
Yeah, I very well aware. I sat in on the Rules Committee meeting on that.
Okay.
Very well aware of that, and if you'd like an explanation as to why we can't do that, happy to do that for you later
Okay.
in the meeting.
I would like one, yeah.
Okay. Member Moss.
So I was comfortable with continuing the matter because as we were going through the votes, it was clear that everyone felt a violation had happened, and I didn't feel like it was appropriate for us to dismiss a matter as if there was no violation because we were having a disagreement over what the exact violation was. And that's why I felt it was appropriate for us to have a broader discussion.
Did member Josh Wolf express why he voted? Yeah,
The
go
chair,
ahead, Member Kanata.
I think this is my memory of it. And I remember, I think I remember that the first vote that included not sending anybody knowledgeable also contained a 67-25. Right, is that correct? Okay.
Yes.
So that was defeated because Member Moss and Member Highland didn't think that that they should be penalized for not sending somebody again. Then the second vote was just the 67-25, and I believe Member Josh Wolf voted no on it because I believe he thought that there should have been also
I
the
see.
violation for not sending a knowledgeable person.
Got it. Okay. All right. So I'm going to leave it up to you folks now. Somebody want to make a motion?
I think a motion was made and seconded, wasn't
There
it?
was no.
No.
Oh,
we
there's
were.
not. That was okay.
It's an explanation.
I mean, I'll make a motion to find a Section 67.25 violation
For timeliness.
for timeliness.
I'll second that.
So moved by Member Moss, seconded by Member Tesfaye. Any public comment? Seeing no public comment, members, any last discussion items on the motion? Seeing none, please call roll.
Josh Wolf absent. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Highland.
All right.
Highland, aye. Member Eldon.
Aye.
Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Please call next item. Well,
It's not 5 o'clock
It's not
yet.
5 o'clock. Okay, great.
Next on the agenda, item number 5, file number 17057, complaint filed by Denta Tedeschi against George Coltran and Robin Wright, Office of the City Attorney, for allegedly violating Administrative Code, Chapter 67, by failing to protect the right to privacy of a member of the public.
Okay, before we start, was this a continued item?
No, it was not a continued item. This came from the Complaint Committee from July 25th.
So just to ask, are there any other items on today's agenda that were continued from the last meeting?
No, not that I'm aware of.
Okay,
None.
thank you. All right, just so we don't have to do a repeat. Okay. Mr. Tedeschi, you have...
Sorry, how do I?
Oh, he needs the overhead. Okay, you have 5 minutes to present Mr. Tedeschi. Can you zoom in on that? Yeah.
Okay.
Don't start the clock yet. It needs to be focused. There you go. Whenever you're ready.
Sure. This is, again, this has all to do with all my other complaints. They're all connected. This is regarding the SFMTA's banning me because my service animal on the historic cable cars due to a driver's fear of my service animal, who's a pit bull. But what they say was that she was not on my lap and in between my legs. So I got this revocation at the place of my residence. It was delivered in a folder, just manila folder with all my information available to the housing coordinator at the place I'm staying at. The same housing coordinator, which I had a HUD complaint regarding many issues, and that actually HUD found in favor for me, and basically this email I sent to John Haley, the chairman, the director of transit at SFMTA, after I got an email from him revoking my privileges on the 1st. On the 2nd, on the 2nd of February, I emailed them back saying that I indeed am appealing this revocation. Later on, I found out that George Cawthron is the one who actually delivered the revocation on the 7th. I already had this information, so it wasn't a surprise to me. But when I got it from my coordinator, I was surprised, and I actually emailed John Haley the fact that I was astonished, the fact that this revocation was just plainly sent to my housing coordinator, who later on I found out leaked that to the press. Again, this is before my appeal. The city attorney's office is going to say that this is public knowledge. I can certainly understand that after my appeal on this particular issue, after the due process that that the city owes me to this whole incident, and these are and this is what I as you can see here, this is the publication by Joe Fitzgerald. Sorry, on February 7th, the same date that this revocation was actually sent to my house. And these are the comments that I had to endure from different people who I don't know, but basically, calling me a liar, calling me this, calling me that. And this is, again, because of this leak, because of what this gentleman did. This is actually a proof. On February 6th, I got a text from Joe Fitzgerald saying, "Tad, you got banned from the cable cars?" This is him basically confirming the story that the leaked story that he got from what I'm assuming is either the city attorney's office or my housing coordinator. Again, a violation of my privacy. As I already had this information with me. And again, this is another email that I sent on February 20th, 2017 to Mr. Haley, again outlining how I was I have to deal with a stranger coming up to me before my even appeal hearing is heard, asking me about this. I have a right to privacy. I have a right to due process. I wasn't given one. And this is, again, has to do with the Mayor's Office on Disability, which you guys unfortunately found not for my complaint against them, but I'm telling you, it has all to do with the Mayor's Office on Disability, the OCC, City Attorney's Office, SFMTA, and again, this is all related, and this is unfortunate. This should not be allowed. Please find in favor for my complaint.
Okay, thank you. Are any persons or witnesses provide any facts or evidence on behalf of the petitioner? Are you speaking on behalf of the petitioner?
Oh, I'm sorry. Excuse me. No, not
Okay,
on behalf
thank
of
you.
the petitioner.
Seeing none, respondent, you have 5 minutes. Please state your name for the record.
Certainly. Good afternoon, task force members. My name is John Cote. I'm the communications director for the city attorney's office. So I trust you are familiar with the responses that I provided in writing on June 8th and July 17th on this matter. So I won't rehash all the details in there. I just wanted to make 3 quick points on this. And the first is really a threshold matter, and it's of the opinion of attorneys in our office that the substance of this complaint does not fall within the jurisdiction of the Sunshine Ordinance Task Force. As you well know, the task force has jurisdiction over matters that include the conduct of public meetings and access to public records. This situation involves neither of those 2 things. This involves service of a document on an individual, and these documents relate to an administrative proceeding. This is beyond the purview of the Sunshine Ordinance Task Force. Moving on, even if the task force had jurisdiction over this, there was not a privacy issue here. The documents that were served were all public records. Anyone could request these documents from the city and receive them. They contained no personal information that was protected by the right of privacy. The last point that I want to make is this was something that had arisen in one of the earlier proceedings, questions about Administrative Code Chapter 67.24D2, and that simply does not apply to this situation. This was a question that had arisen from another member at an earlier proceeding, and that code section only applies when there is a public records request. Again, there is no public records request here. And secondly, that code section also applies exclusively to the enforcement of criminal law, and it applies only to law enforcement activity by the district attorney, the police chief, or the sheriff. Our office does not deal in criminal law. It deals with civil law, and that section is not relevant here. So I'm happy to answer any questions that task force members may have.
Thank you. We may. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none. Members?
I'd like to move that we don't have jurisdiction on this case.
I'd like to second that motion.
Was jurisdiction found already?
Okay,
Yeah.
hold on.
Through the chair,
Yes.
we have jurisdiction in that it's a city organization, blah, blah, city department. I just don't think it's a sunshine case. So then what would that officially be called?
Subject matter jurisdiction.
That,
Right, okay.
And that was the same line of questioning that occurred at the complaint committee. We didn't think there were any more facts that we could
Right.
ask either
Hold
party
on.
to.
I just want to recognize an motion's on the floor. It's moved by Member Moss, second by Member Tesfaye. Continue.
We didn't think that there were any more facts that could be gathered to support any other kind of violation under the Sunshine Ordinance. We did an extensive line of questioning, trying to figure out, what kind of a case this was. Was there supposed to be some type of an exemption that should have kept this information private? Was it criminal? Was it civil? But there was no further information that we could gather to find any other kind of violation, which is why it's here before you now. But as we have decided earlier, that the complaint committee is not making recommendations as to whether a violation was found or not. So,
I just have a quick question. I don't recall, did the complaint committee find jurisdiction?
we found jurisdiction that this was an agency that we have jurisdiction over.
Got it. But as DCA COLA stated,
It's different from
subject matter. Okay, got it. Member Canada.
Explain subject matter jurisdiction, please.
DCA COLA.
Well, the city attorney's office is a city agency or department that the Sunshine Ordinance or the Sunshine Task Force has jurisdiction to hear complaints over. The subject matter jurisdiction is to determine whether or not it's a complaint that is within your realm to handle.
Okay, thank you. So I have a couple of questions for, I guess, both parties. The first question is who requested these documents be delivered to the complainant?
Again, John Cote, Communications Director for the City Attorney's Office. So my understanding is that the SFMTA requested that the documents be delivered. The service of these documents were a benefit to the complainant here because they were advising him of the appeal process. Okay. And the MTA requested our office's assistance in providing those documents, and we did so.
So since you used the word service, why were they not served to the individual? Why were they served to a third party?
Because our investigator was not allowed access to the individual. We were denied access at the point of entry in the SRO hotel, and they said members of anyone who's not a resident is not allowed past this point, and so the service was given to the hotel manager.
I've been served papers, and every time they tried when I wasn't home, they took the papers away, and they came back and kept trying until I was home to serve them to me. Is that not a general procedure?
I know. Go ahead.
I'd have to find out more info on that. I'm not aware that that's the general procedure.
I don't see where this line of questioning has to do with anything under Section 67. Maybe you can let us know where you're going before we go any further.
I don't know either. I'm just trying to find out why somebody's, and maybe we're not the body to adjudicate this, but I'm trying to find out why somebody who didn't request these documents had documents about them given to a third party.
Okay.
That's all.
DCA Cola.
Through the chair, not that it's really relevant, but service through a third party is allowed in cases where there's a doorman or a front desk at a place of business, something like that.
Okay, thank you.
Yeah. Okay. Any other discussion? Okay. Any public comment?
Can I actually answer because he actually asked both parties?
Actually,
don't I have a right to answer that?
Hold on a minute. Okay.
Okay.
We didn't go through rebuttals, the full process, so I'm going to hold the motion until we finish our regular process. Mr. Tedeschi, if you just step aside for a second, the petitioner gets an opportunity to rebut. If Mr. Cote, do you have any further comments, any rebuttal? Okay, Mr. Tedeschi, your turn. 3 minutes for rebuttal. Mr. Tedeschi? Yeah.
Again, I have a right to privacy. Number one. Number two, this is just an example of papers that were served to my door. The response from the city attorney's office saying that that they were not allowed is not valid. Number one. Number two, they also had my address as opposed to delivering it that way. Again, August. This is the Office of Cities. This is OCC letter that I got. The date is right there. They have my address. It's public information. They could have served it that way. Number three, also kind of strangely, I got on the 24th of January a letter from SFMTA with the same information, again with a just bizarre. At the very least, if you don't see your jurisdiction over this matter, I please ask that you refer this to the Ethics Commission at the very least. This is unethical behavior on the part of the City Attorney's Office. I don't also know why Mr. Cawthorn is not here. He's not present. He should be present to answer your questions and to answer his thoughts on why he did what he did. This has been a smear campaign from from the start. You will know more information, I believe, in the coming months. I have an FTA complaint regarding all of this, but this is wrong. And if you don't find for me here, please forward my complaint to some city agency that can actually see, that can give me at least a fair shot on at least saying yay or nay, this was wrong, which I'm saying it is. It's unethical. It was wrong. Yeah, that's it. Thank you for your time.
Thank you. Just for your edification and the public, the task force hears cases on violations of the Sunshine Ordinance with regards to requests or public meetings, things like that, not on administrative procedure or any other procedures that the city does on a day-to-day business. As far as referral, our only ability is to refer to the Ethics Commission when there's willful failure, when there's a refusal to obey the Sunshine Ordinance, which this case does not fall into that criteria. So we really don't have any authority to forward any of our cases to any other. This is kind of the end of the line with regards to Sunshine Ordinance cases. The only other place that it could be further dealt with is in a court of law. So with that, what's called public comment on the motion.
Through the chair, before we do that, I'm wondering, since we've had this discussion, if the makers of the motion wanted to amend it, because it sounds like we do have jurisdiction, but we don't have anything to vote on, and that's a little different than the motion that's on the floor. I'm afraid the motion on the floor might fail based on that, or if they can clarify what the motion really means, maybe we can refresh that.
So I'll tell you, the complaint committee found in jurisdiction because the city attorney's office is a city agency or department that falls within the jurisdiction of the Sunshine Ordinance. They didn't necessarily find that the subject matter, the merits of the case, falls within the jurisdiction. The motion on the floor is to find that the Sunshine Task Force does not have jurisdiction on the subject matter.
Okay.
Any other questions? Everybody clear? Can we go for a vote? Please call a roll.
Oh, could you repeat the motion, though, before you roll it?
The motion is to find that the Sunshine Ordinance Task Force does not have jurisdiction over the subject matter
Okay. Got it.
at issue. On that
I've already called public comment. I called public comment.
On that motion, Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
No.
Hyland, no. Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Very good. Call the next item, please.
We can go take general public comment at this time?
Yeah, general public comment. We'll now open up the floor for general public comment on items not on today's agenda and within the jurisdiction of the Sunshine Ordinance Task Force.
Ann Trickey of the Arts Commission is a pathological liar. At the San Francisco Board of Permits and Appeals hearing last month, she claimed that a 5-story landmark building in Midtown Manhattan was a Japanese restaurant because she did a Google Maps search and found a Japanese restaurant. She also claimed that she had a photo of mailboxes in the building and my name was not on them. There are no mailboxes in that building. 2 weeks ago, she called my family in New York, in Manhattan. She called an 80-year-old non-English speaking couple who were scared, didn't know what she wanted, and they filed police reports on her. Ann Trickey also claimed she had a photo of me selling mass-produced items from a table on Market Street, didn't state the date and time, and her evidence was a Google Map photo of a street corner where I wasn't in the photo. After the Board of Appeals hearing, Margaret Baumgardner, a lawyer from the San Francisco City Attorney's Office, took the documents which were on the projector and had them in her bag. When I went to the bathroom. When I came back, I screamed that these were not public documents and to take them out of her bag. These were tenants lists and tax things on the building in question. So there's a complaint against her at the State Bar. It's my public comment.
Seeing no further public comment is closed.
Next on the agenda, item number 6, file number 17077, complaint filed by Ann Trickey against Dwight Moore, Office of the City Attorney, for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, before we start, anybody from EOT want to provide a summary of this case?
Oh, shoot.
Want to help us out?
Oh, crap. Sorry. Damn it. I prepped the other one. Do you remember this? We're looking.
Okay.
Give me one. This was the August
15th.
Okay, yeah, I have that.
Mr. Chairman?
Yeah.
I can provide a brief summary.
Go ahead.
At the last meeting, the Office of City Attorney did acknowledge that the response to request was late, as the recipient of the email was out of the office for over 2 weeks. Mr. Cote stated that an automated response to incoming emails was sent to Mr. Bo informing of the planned absence. So it appears that it was sent to a person who was out of the office. An auto response was provided, but the response was late.
Okay.
And through the chair, yeah, we recommended to move this without recommendation. Do you remember why we didn't have a recommendation? I don't remember. No.
Okay, let's move ahead. Ms. Trevaux, 5 minutes.
Which actually happened at that meeting was the city attorney representative was going to search for this disc. I provided a Xerox copy of it in the file. Member Fisher said, that's evidence. I don't want to touch that. Let's refer it up pending advice from the city attorney. So basically, nothing came back as a response that Dwight Moore was on vacation, and there's nothing in the file to attest to that. These are 2 violations, 67.25 for the late response, and the response only came after I filed a formal complaint, and it was made to the task force, and a violation of 6724B2, public information that must be disclosed. When a case is adjudicated and finished, there are documents that must be released, and they would be investigative notes. I enclosed a copy of the California Penal Code in there, which talks about how discovery issues should take place. That Xerox copy of the CD should not even have been accepted by the Superior Court as evidence in the first place, and I've included the California Code. So basically, what Member Tessifa said twice is that once a case is finished and adjudicated, investigative notes are made available, and that's what I would like to see. I have not gotten any information, any evidence whatsoever. I've spent a year on this case, and it was reversed in full for various procedural reasons, and this was one of them. So the citations that the city attorney's office used in their response letters are wrong. The California Evidence Code 924 applies only in criminal cases, not in civil. The other government codes that they cite don't pertain because the city attorney's office is not a law enforcement. They are not a representative charged with administration or enforcement of the law. They're not a person of a Crime Stopper organization, and that's it. There are 5 things that don't apply in this case, so there's no reason not to give me over the investigative notes.
Thank you. Are there any persons or witnesses to provide any additional facts or evidence on behalf of the petitioner? Seeing none, respondent. Mr. Cote, again, you have 5 minutes.
Thank you. Good evening again, task force members. John Cote, Communications Director for the City Attorney's Office. If I could get access to the overhead projector. Again, I trust you're familiar with my July 18th written response on this issue, specifically to the point of whether or not Mr. Moore had an out-of-office notification on his email and whether or not Ms. Trabeau actually received that notification. I wanted to draw your attention to this document, which is a printout, as you'll see, with Dwight Moore in the City Attorney's Office of his out-of-office summary. Dated June 22nd, 2017. Here is a list of everyone who received the out-of-office notification. The list continues and includes right here atrabeau10@aol.com. And I'm happy to provide copies of this to anyone on the task force, as well as I believe Mr. Trabeau is aware of it. On the second issue of whether or not the city attorney's office was responsive, I would point you to the response that we provided on July 13th, once we were aware that this immediate disclosure request had been made, once Mr. Moore had returned to the office. And in there, we indicate that, as you'll note from the original request that Ms. Trabeau had sent in, she is requesting all documents concerning phone calls made from Ann Trabeau to Barbara Sklar in 2016, and requests copies of all SFPD police reports and investigative notes made by Dwight Moore on same case, CCSF, Sklar, and Trabeau. It is the position of our office that any investigative notes that Mr. Moore may have are exempt from disclosure under attorney-client privilege and attorney-client work product doctrine. And I'm happy to answer any questions the task force members may have.
That's it?
That's it.
Okay, thank you.
Sure.
We may ask you back for questions.
Sure.
Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? I'm sorry, Member Canada.
Yeah, my only thoughts on this are, and we've had this issue before, is the fact that with out-of-office responses, the fact that there is technology out there to not just send an out-of-office response, but actually forward a request to another person who is in the office. And I know the IT department hasn't come up with any official way to do that, but it seems like a department should cover itself.
Yeah, we did find on several occasions that if a person's going to be out of office, as in this case, that the respondent has showed that there was more than a dozen people that also would have received it, that somebody from the office should respond positively. Auto responses are not necessarily considered a response that we have found, because they don't really help anybody do anything as per what the ordinance is requiring. Anything else, folks? We move to rebuttals.
Can I ask a question
Go
or
ahead.
just thoughts
Member
from?
testify.
Thank you. Thoughts from the group. How about an out-of-office message that tells you to contact someone else? Like, I am out of the office. Please contact so-and-so for assistance on these matters. Contact so-and-so for assistance on these X matters, etc.
Well, I think under the rules for, I think that may be appropriate. The question is whether we hold that it is applicable under the ordinance. What does the ordinance require? It requires an active response from and we've held this on a number of occasions. It requires an active response upon the respondent, and if no waiting's going to be available, and the person needs documents
If no one's available.
if no one is available from the respondent side, and the requester needs documents that may be available and they're doing an IDR because of the timeliness on their end, then no response, just an email response with no further action.
I meant, what if the response said contact so-and-so for matters regarding sunshine ordinance? Should the petitioner or should the requester be contacting the other email address? Or?
The question is it incumbent upon the requester
that's what I'm asking.
to do that, then to have to continue to it's almost like continuing to file a request over and over again until they get in touch with somebody. It's a responsibility of the office, the department, the respondent to serve the public in this way. It shouldn't just be left to there's an automatic response, because then that can go on ad infinitum. So that's one of the things we found. I think it was with it was either the Arts Commission or the Planning Department, where that kept happening over and over again. People weren't able to get their documents, and we found that it was incumbent upon the department to keep track, create a listserv that everybody, that's the main sunshine
That's true,
request kind of thing. So they're actually physical people that will respond.
I agree with that, but don't requesters have the right to contact anyone?
They can.
Yeah, so I would just be concerned, like, if a requester has the right to contact anyone, but then that person's on vacation and says, if this is a sunshine matter, contact so-and-so. But the requester did not contact the designated email that is like a lister for a bunch of people that work on
Well, the question is certainly I would hold that, personally, I would hold that a requester can certainly do any action they want. If they don't get a response from somebody, they can call whoever. Just call the whole directory. But the question is what is the responsibility of the city with regards to compliance with the ordinance, and whether does an auto response with then no answer after that, or an untimely answer after that, comply with the ordinance?
I guess I'm having concerns because it's like, should every single person, every city employee's email be being checked by someone else when they're out of town? Can they not put an out of office saying, contact so-and-so for sunshine matters?
I think what we have held was that it's responsibility of the respondent to provide a person to contact.
Okay, so then so someone else doesn't need to be checking their email, but checking the person's email, but they need to put someone in their email address. I mean, in their out of office to cover them for Sunshine Matters.
Right, exactly.
Okay,
That
that's
they would
fine.
CC them. We have suggested to create a listserv, so there are a number of people, you
That's
know.
only if it's a Sunshine specific email address. It would be a listserv. Like, your email address wouldn't be a listserv, so.
That's right.
Right,
Right.
okay. That
That's-
makes more sense. I was getting a little confused in the situation because this person did have an out-of-office message, but I guess the out-of-office message did not say that these people listed here received.
I think if you look at what's up on the screen, this was the auto response, Mr. Cote.
This is everyone who received the auto response. And what did the auto response say?
I don't have an actual copy of the auto
Okay.
response.
What?
If I could point out, though, that our office has a central email address that is monitored throughout business hours for sunshine disclosure requests. It's info@sfcityattorney.org, is all over our website, and it is staffed and monitored throughout all working hours. However, in this case, Mr. Bowe chose not to send the request to that address.
Well, there's no requirement for a person to use a centralized email address because they're looking or trying to contact the actual custodian that may have the records, and that's primary for the ordinance. So if they're trying to contact general information from the department, they don't know who in the department may have it, that's a different story. But if a requester is asking for at a specific custodian, that's who they think has the information. And the ordinance also provides that if they don't have the information, they should assist them to try and find the person that does.
Absolutely.
Okay.
And when somebody's in the office, they know to
Got it.
forward any IDR request to that address, which is monitored all the time. But in this instance,
Got it.
when someone's out of town, that didn't happen until they returned from vacation.
Understood. Member Eldon.
From there,
In the microphone, please.
the issue is that when he did get back into town, he didn't respond until the complaint came in, and then you responded, but then you said there's nothing to share. To summarize your position.
Yeah. I mean,
Well, the complaint is on timeliness.
right.
So
it's, the way we were looking at it was like, there was a secondary issue, but it didn't seem, we didn't feel comfortable making a recommendation that they should have disclosed more because of attorney-client privilege. That was the second issue that Ann Chabot had brought up today. But the main issue was like, okay, there's autoresponder. How do we want to adjudicate that issue?
Right. I just want to advise us all that we go by with what the intake form for the complaint is, not by what is added on maybe later. We should really try to keep to what the case is supposed to be focused on based upon what the petitioner requested for us to do. So in this case, from what I've been reading in our packet, that it's that this was based on timeliness.
There have been times when we've found other violations.
No, I understand that, but this specifically, we're not going. The thing is we're not going to go on a treasure hunt. Okay, so if the requester is stating that the petitioner is stating that there was a timeliness issue, then that's what we focus on. Okay, if they want to expand on that, they can file a new petition, or they could have included it as like a bullet list of items. Okay, so anything else for the good of the cause? Okay, great. Let's move to rebuttals. Petitioner first, Mr. Cote. You have 3 minutes.
I think he's the respondent, I'm the petitioner.
The respondent goes first for rebuttals.
Oh, you second.
I'm sorry.
Thank you, Chair Wolf. Again, I'll be brief. I just want to reemphasize the point that while certainly we understand that individuals within the department are responsible for responding to sunshine requests. We do have a system set up in place where we do have one centralized email address that is used for sunshine requests. It's where we direct those requests. It is monitored throughout the day and responded to promptly. And I just wanted to note that we have that in place, and happy to answer any other additional questions you may have.
Okay, thank you. Ms. Chabot, 3 minutes.
Okay,
rebuttal.
here is page 120 of your packet. The original IDR sent on June 21st at 11:58 was sent to dwight.moore@sfgov.org. What the representative has shown you is a different email account that I knew nothing about.
Can you move it down? We can't see what you're pointing.
I'm sorry. Dwight.moore. Oh, down further.
Bullet down.
Right there? Dwight.moore at city ATT, I guess it's gov. I didn't even know anything about that. So this is the address that I sent it to. I did not receive an auto away response and did not receive anything until I filed the formal complaint. I would like just to read to you the section of the ordinance that I'm referring to, which is 6724 2 B2, litigation material. Unless otherwise privileged under California law, when litigation is finally adjudicated or otherwise settled, records of all communications between the department and the adverse party shall be subject to disclosure, including the text and terms of any settlement. I did not send an email to Dwight Moore at cityatt.gov. Didn't happen. I didn't even know about that email.
Okay, thank you. Any other questions? Yeah.
I have one for the respondent. Sorry. I'm just curious about this document that you have up here and how you were able to generate that.
Sure. Happy to clarify. So this is when our office uses Lotus Notes.
What?
Lotus Notes. It's our email software. So it provides you an automated list that shows up in your inbox saying, while you were out, once you turn off your out of office notification, here's everyone who was notified that you were out of office. So this is that notification email that Mr. Moore received. Now,
why is the city attorney on Lotus Notes while everyone else in the city is not on Lotus Notes?
It's a good question. I think it's one that's not necessarily.
I'm just curious because we've had this come before, so this is the first time somebody's provided us a document like this. And it's because obviously you have a system that does it and everybody else's doesn't.
So we, as far as why we first got on Lotus Notes, that's a little something beyond my purview.
Okay.
But I can tell you right now that we are in the process of transitioning to Outlook. There's a couple folks in the office who are piloting it, and that will be happening at some point in the future. But as to another sort of quirk, if you will, of Lotus Notes, Ms. Rabeau had drawn attention to the from and to line on this email. As you'll note, that's not a complete email address. This is dwight.moore@sfgov.org. It just populates in your inbox as a shorthand saying Dwight Moore, City Attorney, saying, there's lots of people with at sfgov.org email addresses. What this does is show which department it's from. It's not the full email address. It's a shorthand descriptor of it.
You may or may not know the answer to this question, but if somebody were to reply to this, would Mr. Moore get the reply?
Yes, he would.
Okay. And the other question I have was, I should have asked earlier, was Do you have a policy in your office that when people are out of the office for like vacation or sick leave or whatever, that there is a point person to answer or check their email with regards to sunshine requests or anything like that? This is along the lines of what Member Tesfaye was asking about.
Absolutely. I'm familiar with her question. I don't know the answer when it concerns specifically sunshine requests. I know it's the common practice of the office when an individual is out of the office to have your out of office notification on and refer to either another member of the team or including potentially a legal secretary or another attorney on the team. Now, on the issue specifically of sunshine.
Does this message say that in its content?
I'd have to go back and look.
Is the message in here?
It's not. This is the summary of who received the message. It's not the actual message.
The headers. Okay.
Yeah.
All right. Thank you.
Sure.
I'll give you the opportunity, Ms. Trevaux. Go ahead. What's your point? What are you making a point about the timeliness issue?
Absolutely.
Okay.
Okay, this IDR was sent June 21, 2007. I find it interesting that this generated the next day. If this man was out of office for 10 days, as the representative said, why would he suddenly generate an email the next day? It's highly suspect.
Well, it's an auto response, so it just automatically happens.
So in one day, this guy got all these emails, and he doesn't have the email response that went to all these people? Seems strange.
Yeah.
That's really all I can say.
Well, thank you for making that point.
Thank you.
All right, members. You guys okay over there? Yeah. All right. Anything else for the good of the cause? Is there a motion?
I have another question. Just is it?
Go ahead. If it's pertinent to timeliness.
Well, it's pertinent to the issue of the date here, because I thought, and correct me if I'm wrong, but I thought you said that this gets generated when the person comes back and takes his out of office off.
It's generated when the out of office is set to be turned off. So in this instance, Mr. Moore had his out of office. He was scheduled to return to the office on the 22nd. This is a summary of, it's not of all the emails of that day. It's the entire time he was out of the office.
So he got back on the 22nd?
Yeah, well, this is a point of clarification. He actually didn't get back to the office on the 22nd. His flight was delayed. He was out of the country, and his flight was delayed, and he had to submit some additional paperwork because he was gone even longer. But he was scheduled to return on the 22nd. He actually returned to the office, I believe it was the 23rd or 24th, but he wasn't actually back this day.
So
he was back later.
Email system, and so what you do when you're going out of office, you will say, I want it from this date to this date.
Right.
So he would have expected that he would be back at work on the 22nd in the morning, so you would have it going until then.
Right.
So it automatically would do that for the date he said he was coming back.
I understand that Outlook has that too. So if he got back on the 24th, then for 2 days, he would not have had a message sent to anybody sending an email to him.
There would be no more auto responses
Right.
at that point.
Okay.
This is just a summary of everybody during that period.
Right.
Right. So we don't actually have. We're not actually seeing the actual auto response.
Correct.
At this point. Okay. Member Eldon.
I think I'm ready to make a motion to find a violation for 6725, failure to respond, based on our existing reading of the ordinance, that they need to be sharing they need to have other people in the office reading this and responding.
Moved by Member Eldon.
I'll second it.
Second by Member Kanata. Any further discussion on this matter? Any public comment on this matter? Seeing none, can we vote?
Just to clarify, this is motion to find a violation of 67.25 for failure to respond in a timely manner.
Right.
Okay, on that motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon.
Aye.
Eldon, aye. Josh Wolf absent. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Thank you. Can we take a 10-minute recess, please?
The meeting is in recess for 10 minutes.
Okay, we'll call the meeting back to order. Call the next item, please.
Next on the agenda, item number 7, reconsideration of complaint, file number 17009, complaint filed by William Clark against Tom Cagney and the Arts Commission for alleged violating Administrative Code, Sunshine Ordinance Section 67.5, 67.7 by failing to comply with regulation for policy bodies and post agendas for committee working group of the Arts Commission. May you provide a short summary of the issue?
Can the committee do
I
that?
believe this would be a board issue.
Oh, okay. Okay. Sure.
Just
Go
for
ahead.
the task force's clarification, the task force previously heard this matter and found that this body was a passive meeting body and found violations related to that. The petitioner has submitted additional documents and requested reconsideration, stating that the new documents show that the working group in question is in fact a policy body instead. I believe that the task force should determine whether or not this new information proves that the working group is a policy body, and if you do so, you should reconsider new violations based on the findings.
Okay. So our work here is to hear the petitioner's new information. If it compels us to find differently than what we have found before, then we will somebody will make a motion for that. And if so, then if the violations that were alleged originally apply, we will determine whether we should go through that hearing process today or whether we should continue it based upon just on time. Okay? Is that clear? Everybody clear on that? Where we're at? Okay, good. Okay, so Mr. Clark?
Hello, task force members. I thought you were going to take it up at the last hearing. You said you were going to proceed from after the form of motion was made, not to take this all from the beginning.
Don't start the clock yet. I'm sorry. I'm not following you.
At the reconsideration hearing, which I had, you stated that this hearing today was going to begin at the point when the original motion was made and before it was voted on, and then proceed from that point.
Right. So
Okay.
we will.
Okay.
Right. So
okay, just so I understand.
If what you provide compels us to a different outcome than what was on the floor at that time, which was it being a passive meeting body, would either be rescinded or amended at that point.
Okay.
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 So that's where we're at right now.
Okay. At the last hearing, I presented you with
Clarify 5 minutes?
5 minutes.
Yes, thank you.
William J. Clark. At the reconsideration hearing, when I
Hold on a minute. Stop clock. Can you make his microphone a little louder?
It's max set.
You want me to go closer?
Can we switch
My
to the
voice-
other? I know, but it's really hard for me to hear. Can we try the other microphone?
This one?
Yeah, hold on a second.
Hello? 1, 2,
That's
3.
as loud as it goes?
It's as high as it gets
Okay,
right
all right. Either one, never mind. Thank you.
At the
now.
last
Sorry, give me a moment. I need to
One
switch
moment.
back.
Thank you. Proceed.
Okay, at the last request, I presented you with these two documents, one being the proposed work plan to modernize the street arts program, and then this other one which contained the meeting notes for 5 different meetings of the community working group. And in my complaint, my complaint was that the community working group is a policy body because it was created by a policy body, which is defined in section, I believe it's section 67.3. Subsection D, which a policy body says that any advisory board, commission, committee, or body created by the initiative of a policy body. In my hearing, I proved to you that the working group, and in this document to modernize the working group, it stated that the community working group was approved by the Full Arts Commission. It was created by the Full Arts Commission. I gave you the dates, I gave you the resolution numbers, and then I had argued that because the working group was created by a policy body, and it's an advisory body to the Arts Commission, that therefore it should be defined as a policy body. In the working group documents, it clearly states that under 2.3, it says, as recommended by the working group, there is now a fee for rescheduling a screening, blah, blah, blah. It says that under 1.3, it says establish the ad hoc working group. And then it also states several other things that have been implemented as a result of these working group meetings and were implemented by the Arts Commission after the advice of the community working group, that the staff took the advice of the community working group and put them into effect. And the point being is we left off that what is a policy body? And I clearly stated that the policy body is any body, any advisory group, body, committee that's created by a policy body. The Arts Commission is a policy body, therefore the ad hoc committee is a policy body because it advises the Arts Commission as to what recommendations they should make and what should be done. And I stated that I believe it's a violation of section 67.5 of the Sunshine Ordinance, because that says that all meetings of any policy body shall be open and public and governed by the provisions of the Brown Act. And so the violation, I'm saying, is 67.5. The determination is the working group a advisory body? Did they advise the Arts Commission on what matters to implement? The answer to that is contained in both of these documents, clearly show that these meetings were held to get advice from the working group as to what changes should be made, what policy changes should be made by the Arts Commission. The Arts Commission has made several policy changes based on the recommendations of this ad hoc community working group. So the only question, like I said, you have to answer, which you've discussed several times now, is was the community working group a policy body because it was created by a policy body? And therefore, if that's the case, were these secret meetings that were held by this working group, and the fact that no minutes were given, no one's allowed to attend it other than a select group of people, did that violate section 67.5 of the Sunshine Ordinance? So the question for you, I guess, again, is to rule on whether or not this is a passive meeting body or a policy meeting body. It's not a passive meeting body because a passive meeting body is not one that's created by a policy body. So I would request that you would would you go back and you would re-vote on your previous motion, vote this in as a policy body, and then enforce the violation of 67.5. If any questions, I'd be glad to answer.
Thank you. Is the petitioner here? I mean, the respondent here?
Yes.
You are? Okay. I'm sorry?
Oh, no, sorry.
No, I'm actually
That's not the full hearing.
Right, it's not a full hearing process. I just want to make sure somebody from the Arts Commission is here to answer any questions. Okay, members. Member Canada.
So I think the distinction here is what type of body it is. So 67 3C, which says passive meeting body, C1, advisory committee. So a passive meeting body can advise. Advisory committees created by the initiative of a member of a policy body, the mayor or a department head. And the difference of a policy body is it's created by the policy body. So we voted at once that this was a passive meeting body, and I'm trying to remember, did we determine how this was created?
Well, I think look, the burden at this point is on the petitioner for the reconsideration to compel a change, okay? So I think there needs to be some questions as to origin, okay? And I think some of this discussion we had at the original hearing on this. So I'll start off some questioning with this to Mr. Clark. Mr. Clark, the documents that you're showing us physically, are those in the record here today?
Yes, they were in the record at your last hearing.
No, this is a new hearing.
No, it was at the last hearing that
I understand that, but the idea here is for you to provide additional records or documents or information that is new that would show us that we were incorrect.
I understand. All I'm saying is it's in your doc there because I presented it at the last hearing, so you could have your
so
vote
then
to
let me do
reconsider.
this. Can you please tell us on what page you're making these references to?
I have to get the book. You should have the document which is titled Proposed Work Plan to Modernize the Street Arts Licensing Program.
So
Page number, please.
I have to.
Actually, there's no page number. So if you scroll down where you see the orange highlighting, it's the page after the last page of highlight. You'll see it says SO complaint number 17009, and in blue, it's at the top. It says proposed work plan to modernize the street artists licensing program.
Right.
That's the way that's what he's going to be referencing to. So.
And in it, I'm in section 1.3, establish the ad hoc community working group. That shows that that's part of the work plan that was passed and voted and approved by the Full Arts Commission.
Okay, so do you have the? I think what I would have expected to see is the actual resolution or action item that the commission had made, so because that would determine that.
I gave that in my first hearing.
I understand
and that's
that,
in the records.
But under this particular process, you need to provide all the information that is related to it. This is the high bar for reconsideration. So you have to make some reference to it so that we can see where we may have misinterpreted it. Please, one person at a time.
Okay.
We have to be able to determine whether, so we can see, so that you can show and tell us definitively where we made a mistake.
I understand that,
Okay.
but this is for additional evidence. This hearing is for new evidence. In the original complaint, and even in it should be in my complaint, I state the resolution number and the very day that the Full Arts Commission voted on creating the work plan.
It's not incumbent for us to have to go searching around for that information. Come on. I mean, the point is, why?
Okay. the Art Commission created this through a resolution. The document itself says this is the proposed work plan. It states in it, establish the working group. The working group was established and met 5 times.
Mr. Clark, we have to go by what the policy body did.
Yes.
The Arts Commission. In their action item for creating this program, okay?
Right.
In the action item, does it specifically state that by their action will create an advisory committee?
Yes. It says in...
Show us where that is.
You know, this is unfair to me.
No, it's
right
not.
Now. Yes, it is, because you have that in the original complaint. I should be able to refer to the original complaint. I mean, I'm telling you that...
Mr. Clark, the reconsideration is for new information
That's right.
provided, not previously submitted information. Previously submitted information has already been considered by this task force. The reconsideration process is for new information not previously submitted.
That's right.
That's right.
I previously submitted the resolution number that the Art Commission did
That would not
it.
be taken into account today because it's not new information. We're only looking at new information.
Well, that's old information.
Right, but for the purpose of the process, of the reconsideration, you have to provide, even if it was previously submitted, you have to provide the evidence that you're showing that what your consideration is trying to compel us to know and to take into reconsideration. You have to provide that. Otherwise we're just sitting here in the lurch. It's not in our record for this particular reconsideration today.
This is the same original complaint.
I understand that, but
that's
the
right.
purpose,
This is the same original.
if you read our complaint process with regards to reconsideration, is to provide new evidence. Okay?
Right.
If the new evidence is, even if it's part and parcel of something that was already submitted.
Look, I understand.
That's all I'm saying is that we will hear what you have to say, but you have to show us where in their action item, that's what I'm asking for, in their action item that was on their agenda when they approved this program.
That's right.
Okay? Did it say in their action item that they would create an advisory committee?
The action item said that they were voting on approving the working plan that was created by Kate Faust. In the working plan was the establishment of the community working group. Now, I didn't realize that I have to re-provide you with the resolution number and the date of that because I assume that's in my original complaint.
I understand that.
I mean,
be it as it may, our procedures specify that all the documents. I see the hands. Hold on a minute. All the documents that apply to the reconsideration should be submitted.
Well, I wasn't told that. I was just told
in our documents.
I was just told that that you were only going to consider the new evidence that I was presenting tonight.
Right, written documents, written evidence.
No evidence that wasn't previously presented in the other hearing.
Right.
So I'm under the information that this hearing is just dealing with the new information that you didn't previously have entered into my original
Right,
complaint.
and so I'm asking for the new information. Okay?
Yeah.
The new information, you're telling me that it's old information.
No, I'm not. I'm telling you that the resolution, that I did not bring the resolution number with me today because I was under the impression we were just going to discuss the new evidence that I presented and am presenting, which includes these 2 documents. This is like the 4th hearing. I presented to you at every hearing the resolution number and the date that the motion was made. And you already ruled previously that it was adopted by the Full Arts Commission in your previous hearings. Now, I can go through the rest of this.
Right. So, and we then also determined that based upon that it was a passive meeting body.
Well, you didn't. The group did. You voted no, that it wasn't a passive meeting body. I'm speaking as the chair of the body. I understand
okay?
that, but you voted no.
It has nothing to do with what my vote is.
But your vote that
it has nothing to do with my vote, sir. It has nothing to do with my vote. I am asking this question on behalf of the rest of the members.
I understand what you're saying. I'm not an idiot. Listen, I'm telling you that previously, when you voted that it was a passive meeting body, you voted on the basis of the section that this gentleman just read to you, that it was on a passive meeting body was given on the initiative of a single member of the group. And I previously presented to you that this was not made by a single member, and therefore it wasn't a passive meeting body. Several members voted that it wasn't a passive meeting body. Several members voted it was. Now that means that some people realized that it wasn't a passive meeting body.
And the bar for reconsideration is to show us some new evidence.
Well, if you're asking me to bring in the resolution again, then I want to request a continuation to bring in the resolution number and the date which the Full Arts Commission voted on and approved that. If you want me to do that, I'll do that. But I'm here today because I've already presented you with that evidence. You took it into consideration. Some of you felt that, you even stated that several times through the hearings, that there was confusion. Is this one member?
I understand. I wanted just to be clear. The purpose of the reconsideration is...
You don't have to restate it. I heard you.
The purpose of the reconsideration is to, if there were documents or records or information that were not part and parcel of the original case that you have found to be new that would bring a compelling difference to the case, that is what it's about. Okay? I'm hearing somewhat that you just want us to re-adjudicate the case.
No, I don't want you to re-adjudicate this at all, and I resent you saying that. Not at all.
I am not trying to be disparaging
at all. I know, but don't imply that I'm trying to read. I'm not doing that at all.
All right, so I'm gonna let other people speak. Member Moss and Member Kanata.
So as I understand it, and this is what I want to make sure I'm getting this right, the document that he's included in here, the proposed work plan, he had previously provided a copy of the agenda or the minutes in which this document was approved. It's just that at the time of that hearing, this document that went through the whole work plan was not available, and this is part of the new documents that he's presented, and that's why we granted the reconsideration.
I recall seeing this document at the last hearing.
Yeah,
at the original hearing.
I didn't
not
recall
at
the original hearing.
I didn't have it.
Yeah, this document I think has always been part of this case.
I didn't have it. I didn't get it until after.
This is part of the new documents.
I think it was given to us by hand last time.
Yeah,
if I remember.
Right.
Was it submitted at the time of the hearing?
At the time of the hearing.
Okay.
And then that's, I think, what prompted many of us to say, hold on, maybe there is something here. And that's why we voted to encourage him to appeal for reconsideration.
Okay, Member Kanata, then Member testify.
The document that we have that was voted on, right? By the full commission.
Right.
That was presented by whom?
Right. That was presented.
No. Who created that document?
That was created by the Art Commission. The Art Commission voted.
You had mentioned. I'm sorry. You had mentioned before that some person brought this.
Kate Faust was hired by the Arts Commission to come up with to create the working and a feasibility study to implement it.
Kate Faust a member of the...
She was hired by the Arts Commission. She was hired by the Arts. She's now a member of the Arts Commission, but originally when she did her report, she was just hired to do a survey and give recommendations and to create the work plan. She created the work plan, and then it was put in front of the full Arts Commission for approval. It was voted on and approved by the full Arts Commission, and in my original complaint, I gave the resolution number and the date that it was voted on.
And part of that plan was to create this committee.
That's correct.
Okay, thank you.
You're welcome. Oh, I don't know. Is it my time now?
I guess, can I, am I next?
Wolf?
I mean,
I already called member testifying.
I guess my concern here is that we have that document with the highlighting on it, that agenda. The document that I feel that I need to see is the actual resolution, and there has been reference made to the actual resolution. It was on March 7th, 2016. We have the resolution number. I haven't seen the actual resolution.
Well, you can go to the Art Commission site and see.
It's not our...
That's not the purpose. It has to be in the record. It has to be, the document needs to be in the packet.
Wait a second. You mean it's not good enough to give you the resolution number and the date that it was voted on, tell you that what it was that was voted on? I gave you I gave the caption of the motion. I gave the motion in my original complaint. Now, if you want to see the actual vote, then before you take action here, then I want to continue this to give me an opportunity to get that actual document. If you need to say that, if you need more than just the resolution number and the date as evidence that it actually took place.
Vice Chair Hyland.
Unless the Arts Commission is willing to stipulate that is true, that the contents of that is true.
Here today.
I don't know if she's prepared to stipulate to that.
And I remember that the other representative that you were trying to get the name of referencing, I think we asked her, based on these working notes, did any policy ensue? And she said yes. So that, I think, convinced a lot of us that, guess what, out of these meetings, real policy is flowing. That's what changed many of our minds, I think.
But isn't the critical part how I'm not saying that wouldn't sway us. I'm just saying that I think what Member Wolf was making reference to is how the body was created, which was through this resolution, this commission resolution. That is what we need to be looking at for the determination.
Okay, so maybe we need to...
If a passive meeting body was asked to review some code, okay, that the person who created the passive meeting body requested, that's not direct advice to the policy body. That person who is running the passive meeting body will take that recommendation, and in their report will give it to the full commission, or not. It's not necessarily a requirement per se. Okay, Member Canada.
I just want, and one more clarification, because I'm looking at this document, the proposed work plan, and on 1.3, so this is a proposed work plan, and I'm assuming it hasn't been voted on yet.
No, this has been voted on.
Now, but when this came out, it says proposed work.
No, this was already voted on when we got this. This was just an update of what had been accomplished at this time. But this had already been voted on and put into creation. That's why, excuse me, sir, that's why at the bottom where it says revised grace period 2.3, it says as recommended by the working group.
Right, and it says the working group was established and met 5 times. So I just want to have it clear when the working group was established, because I'm reading this says proposed to me. And if it was proposed and a working group was created, then it was created by an individual and not by the full commission.
And that's not the case in this. In this case, if you want to time me, it's okay. I mean, it's in this case, the Arts Commission hired Kate Faust to come up with suggestions and recommendations to modernize the street artist program. In the process of doing that, she came up with suggestions which they called the working plan, and those were her recommendations, okay? And that working plan included creating the community working group. Now, her whole entire working plan was put in front of the full Arts Commission for its approval, which it voted to approve the full working plan and to put it into implementation. During that process, they wanted to have secret meetings. They decided they weren't going to have meetings to allow the public to come to, and they created these working notes, these agendas to work on, and then all this policy came out of those meetings and was implemented by the staff of the Arts Commission already. But the actual resolution to vote on the working plan had already taken place when this came out.
But the question is when if a policy body were to create a program, and in the program it created an ad hoc working group, okay? The question is where is the specificity that says the actual ad hoc working group is created by the policy body for the purpose of advising the policy body. Otherwise, it's create any number of working groups or advisory committees. The program do that for its purposes, not for the policy body's purposes, but for the program's purposes. And then that is a very distinct difference.
Well, I hear what you're trying to say. However, in this case, that the Kate Faust recommendations included the working group, creation of the working group, and then they put it into a feasibility study, the language that you're talking about. They had another report called the feasibility study. It's on the Art Commission's website. They have copies there, and in that feasibility study, it states also how they're going to put all this into effect.
I get that, but it goes back to the point, we're only concerned about the creation of the body.
That's right.
Okay?
This was not created by a single individual.
That's fine. We need the resolution.
We need the resolution in order to know that. That's the evidence.
Well, you need the resolution which I gave to you that said it voted on approved the working plan.
I'm looking through the original packet going back to July 17th, June 7th, and I don't see in resolution format anything from the
You don't
Arts
see it
Commission.
in my original complaint?
I'm looking at it, but I don't see the actual document.
I see a reference he's making.
Well, then I'm requesting that this be continued until your next hearing, so I can bring you that document.
So you have the copy of a resolution that was a copy of the actual resolution.
Yeah, I put it into my original complaint.
Here, I see the date and I see the number. I don't see the
Look, the point here for reconsideration is a very high bar. It's incumbent upon the party that is requesting reconsideration, whether it's respondent or petitioner, doesn't matter. It's incumbent upon them to bring the actual new information or evidence to show that to show and compel that there should been a different outcome.
I think that's ridiculous.
That's not. It's go to any.
That's
go to
just
any
my
court. They will require the same thing. Member Moss.
According to the San Francisco Art Commission's submission to this committee, they wrote, the Street Artist Committee approved the work plan for the working group, but that is the extent of its involvement. See the February 18th, 2016 minutes. So I have brought up, per the Arts Commission's letter, the copy of the minutes, which does talk about approving this, and it has a link to the actual item, which is something that this is one I believe we've seen before.
I am objecting to this because it is not incumbent upon us to have to do
then I'm
the work
requesting a
of the
continuance.
petitioner for the
I wanted to show you that this is the document that you may recall from the actual packet that has
On what page? What page?
I'm trying to sort it through what it seems to be 3 or 4 different agenda items over various meetings and trying to figure out where exactly it is so I can give you a page number. But you guys did say a little while ago that you recollect seeing this document before.
No, we did not.
So yeah,
No.
we saw that at the last one. What I'm just trying to flesh out what it is. The document that we are referencing is the same is a version of the document that was approved with updates on what actually happened to it. Now, I recall this document from a previous filing, and I can go in and dig through it and find it. Okay. What this document with the highlighting, which I believe I saw for the first time at the rehearing, is demonstrating that not only did they establish the committee, but the committee actually held 5 meetings. And then he goes through, and the other things sort of show what they did falling into the advisory committee. But I'm just trying to suss out what exactual resolution you're looking for, because in trying to figure it out from the San Francisco Art Commission's view, I believe they actually told us where to find it.
It's what is relevant is what is in writing and what was actually passed by the policy body. What the petitioner of this reconsideration is requesting of us is to recognize that the policy body had created the ad hoc committee, and that the ad hoc committee would advise the policy body itself. Okay, which means that the policy body under 67.3, the policy body in total, not an individual member of the policy body, that's different, but the whole commission had approved to create an ad hoc committee that would answer only to the commission.
Well,
that's the way the definitions. That's the way. No, Mr. Clark. I am talking to other members of the task force.
Well, stated correctly.
This is not a dialogue.
Please have a seat while we're having our discussions.
So what I'm seeing, though, is I'm seeing in the March 7th, 2016 minutes of the full commission that they approved the work plan. I don't know why the full commission didn't attach the document that they approved, but I see it right here in the minutes that they voted on that. And then I see in the Arts Commission submission to us that they also said that the Streets Arts Committee approved this work plan, and that document is available online, which also includes the establishment of this working group.
I understand
so I'm not
that.
sure what needs to be found.
The question is, was the approval of the plan? Did the approval of the plan create an ad hoc committee or some other body? And if it did, who is it answerable to? Who administrates it? Who does it advise? Because that is the specificity of the Sunshine Ordinance with regards to passive meeting bodies and policy bodies.
That's how you tell the difference.
That's how you tell the difference. Okay, if the commission itself said, by creating this plan, we also are creating an ad hoc working group that will make recommendations to us, then that would be different. That's what I'm asking.
Right.
That's what I'm asking the petitioner for the reconsideration.
But I'm confused as well. So are you saying if they provide a list of things that I want you to approve, and one of those lines says create a committee, that's not enough. There needs to be.
That's right.
So what more does a body need to vote on?
They need to, if they say create a committee to help the program out, okay, and that advisory committee will provide advice to the program, that's not advising the policy body.
Well, so I mean, can I hand you a document for us to vote on that says I want to create a subcommittee of the task force and not specify what it does, and then hold those meetings without following the Brown Act, and then this committee can then act and implement those things without having gone through the process?
If you create the committee, you have to charge it with who its it's supposed to be responsible to.
But so if we don't specify that, we can just ignore the Brown Act. We can just keep doing stuff without.
No, it's not necessarily ignoring the Brown Act. It will fall either into a passive meeting body or it'll fall into a policy body.
Right, but
the question is if the policy body actively created. If I said I want to create an IT committee and the IT committee answers to the task force, then that's a policy body. If we were a policy
But if you
body.
said you're going to have an IT committee, but you weren't going to say anything else beyond that, and we voted to approve it, that would not be a policy body.
That more or less would be a policy body because we are creating it in name. Okay, if we said let's create a program to talk about IT issues, and the people who are creating the IT body created a document that had this is what we're going to be doing, and we're going to be creating an advisory committee to help advise us, the IT committee, to advise the IT committee on various different things. That is not the same as the actual task force creating the body itself. The plan, in the plan says, want to create a advisory body to the program or to the subcommittee or for the purpose of that plan. So it doesn't then jump over into the policy body. That's the distinction here. If the Arts Commission said we want to create an advisory body to advise us about issues around the street arts program, that's one thing. But if they had this plan, like in this proposed plan, there are a whole load of other activities going on. And one of those activities was to create an advisory committee to advise the program what to do. So the program operates encapsulated unto itself. Program doesn't answer to the policy body.
Yes, it does.
Okay? Only the people that are running the program answer to the policy body, and how they obtain to get information for whichever way they do it, whether it was part of their plan or not, that it doesn't then automatically make it that the policy body created that body for its own purposes. That's not the way the ordinance was written.
With all due respect, sir, the sunshine.
We're still having a discussion among ourselves.
When do I get to point something out to you what the law actually says?
When we
Because I don't see in the definition of passive body that a committee can create a passive meeting body. That if a committee creates a body, it's inherently a policy body.
Advisory committees. What do you mean? Say that again.
Well, so listen. So an advisory committee is created by either a single member of a policy body, the mayor or department head, or it is any group that meets with the mayor or a department head, or it is related to social, recreational, ceremonial occasions.
What are you reading?
I'm reading the Sunshine Ordinance.
67.
Yeah, I'm not seeing where a committee can create a passive meeting body.
I mean, but what we should be actually looking at is the definition of a policy body. You can't use the definition of a passive body.
So the definition of a policy body is any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors.
Okay. And when I look at the minutes,
or any advisory board, commission, body, committee, or body created by the initiative of a policy body.
Right.
I
and
would
then
say
when
that
you
the
look at the
working
resolution,
group
says,
plan that was voted on is the initiative of a policy body. That is the definition of an initiative of a policy body.
No.
So do you have the
Go ahead.
Do you have the resolution in front of you? Resolution number 0307-16079. Because when I look at
that is
minutes,
one of two resolutions that were
finish.
voted on by the policy body.
When I look at the minutes of the meeting, it says motion to approve the work plan and project scope statement relating to Kate Faust evaluation and feasibility study reports. I don't see the words there, committee, or anything like that's being created.
Right. So I see that, and I don't know why the Arts Commission has not provided that document uploaded online. So in order to try to figure this out, I referred back to the San Francisco Art Commission's own letter, in which they're not even talking about the full Arts Commission. They're talking about the Street Artists Committee,
Right, but
which
the
is also a policy body.
The statute requires that we're looking at how the body was created, which
Right.
means we need to look at this actual resolution. We can't look at circumstantial evidence that makes you believe that it is a committee.
Well, no. So according to the Arts Commission, though, I mean, so maybe it's worth bringing the Arts Commission, because according to their letter, it was initially created by the Street Artists
Either way,
Committee,
that's a circumstantial.
which is also a policy
But that's
body.
circumstantial because it's a letter from them. What is the actual motion? What was the actual resolution? And what does that say?
So I mean, all that I have based on their minutes and agenda is they have the vote, and they have as the attachment the proposed work plan, this document here.
And so how do you see, by approving the work plan, that whatever is in it is automatically advisory to the commission itself?
Well, so that's a great question, but it doesn't matter, because this wasn't the way it was created. Could not be a passive meeting body. It can only be a policy meeting body.
But you're not explaining how or why.
Because the passive meeting body only applies to a narrow group of bodies that are created by a single member of a policy body, or a department head, or the mayor. A committee cannot create a passive meeting body. A policy body can only create another policy body.
The point here is that we're saying is that it's an advisory body. It's a working group. Okay, there wasn't how do you define that working group at that point?
I mean, it doesn't matter what name you call it. The task force is still a committee under Sunshine Orders, even though we call it a task force. Like, if you call it, what's that?
Or it specifies what we are.
Right. So I mean, I don't know. I feel like during testimony I'd heard, because I had specifically asked this question, would this body exist if the commission, if the committees who had voted on it had said, no, you can't go ahead with this working plan, and they said no, it would not have happened. And I remember that we had heard testimony that the Arts Commission was just looking for direction on what kind of body it was. I mean, like, I'm not sure what we're looking for here. Like, I wish there was more information from the Arts Commission online. I wish they had posted their entire packets and that their resolutions were available online. I'm not sure that's the respondent's fault.
But I don't think it's necessary, because the creation of a program that may have a number of activities which may include focus groups, it may include a survey, it may include a working group, or any number of activities that might be in it, are meant for the purposes and the administration by the program itself. And that information is not required or asked for by the commission to be reported to them. Okay? That's where the pure definition is. I'm not speaking about the Arts Commission. I'm talking in generality, because we have to talk in somewhat of a generality, because this could apply to any city department or any agency.
Well, I mean, I don't feel like any agency, I mean, any commission in San Francisco should be able to just create bodies that are going to make suggested policy to them without following the Brown Act. That's what seems weird about this, is that the new information he provided shows the level of which advisory information was given, and I feel like there's information here showing that this working group was created by the Arts Commission and the Streets Arts Committee, and not by just some staffer, and not just by one member, and not by the mayor, and not by a department head. So I don't know, like, there's some third category of meeting group that you guys are discussing that is not a passive meeting body and is not a policy meeting body, but I don't see how, I'm a little reluctant to allow the city commissions to create committees that aren't covered by the ordinance.
The question, but what power do they have? We're talking about an advisory committee that has virtually no power at all. Here's another, for instance. So when I did a training with the code advisory committee from planning the commission, okay, they were operating under the guise that they were a passive meeting body, okay, but when I read the charge, how they got created, they got specifically created by the commission to advise the commission on code, which makes them a policy body. And when they read the ordinance, when I had them read the ordinance on that definition themselves, they all looked like deer in headlights because they realized that they were, in fact, that. Now, if the Planning Commission went to the city planners says we want to create a bunch of advisory committees from members of the public to help us do our work so we can complete and do our work. That's very different definition of what the purpose and the reporting of those advisory committees are meant to do. They are not meant to advise the commission. They're meant to advise the city planners, so the city planners would then go to the commission and say, we've done a number of focus groups, we've done all these other things, we had some community groups get together, and now we're presenting you with this resolution. All those other activities and all those other groups have no application to the commission itself, even though they approved a program that may include those activities of creating advisory bodies. It doesn't mean that they just get created willy-nilly. We found that they were a passive meeting body, so they actually have standing under the ordinance. But there are a number of focus groups and things like that do exist out there that are part of actual programs. I can tell you Rec and Park does it all the time.
Yeah, but that's not what this feels like to me. This feels like, based on the minutes, that they were making very specific policy recommendations that were then enacted, and it troubles me that there are people who feel like they were unable to have input into this process, that there were people who were told to delete videos from their cameras because this was somehow not covered by the Sunshine Ordinance. And I find that troubling. I don't want to go too more in circles, but I'm just stating my position there.
And I think I understand your concern, and I think that Chair Wolf's explanation of the facts is very important. But I think also in the Sunshine Ordinance, a passive meeting body is defined and a policy body is defined. And because policy body is specifically defined, you cannot say a passive meeting is something specific and a passive body is something specific and everything else is a policy body. Policy body is specifically enumerated, and so we have to look at the specific definition. We can't say a passive meeting or a passive body is this specific thing, and this advisory group is obviously not that, which means it's a policy body. That's not how the legal analysis
Right, but the line is any advisory board, commission, committee, or body created by the initiative of a policy body. So what does not apply here? Is it?
It's the creation in actual resolution. We are creating this advisory body. That's the initiative.
That's number 3. Number 4 does not require an ordinance or resolution. Number 4 requires just the initiative.
Isn't that the same thing?
Apparently not by the crafters of the ordinance.
I don't understand how you...
Policy body is number 3, any board, commission, committee, or other body created by ordinance or resolution by the Board of Supervisors, whereas number 4 says any advisory board, commission, committee, or body created by the initiative of a policy body. It does not require an ordinance or resolution.
Wait a second. Number 3 is specific to the Board of Supervisors.
Yeah, and it specifically
Number
mentions an
4 is
ordinance or
specific
resolution.
to a policy body.
Right, but it doesn't use the word resolution in number 4 where it does in number 3.
So do you have a copy of an initiative that was passed by the Arts Commission?
I would say that, if we're going to define what an initiative is, I'm going to say, in my view, if a plan is put before them that creates an advisory body and they vote on the advisory body, that to me is an initiative. I don't know what else would be an initiative.
Well, the question is do the Board of Supervisors approve initiatives?
No, he means
okay.
initiative.
That's the point is if all other bodies other than the Board of Supervisors
look it up.
create their action items are called initiatives, and not because they can't create an ordinance. And they can't, and their resolutions are resolutions for the Board of Supervisors are just like commemorative.
Right,
in
but
that kind of
the
way.
Arts Commission does have a resolution, and they did actually give it a resolution title, whereas the Street Arts Committee...
that could be incorrectly labeled. So the question is if you're asking for what the definition of an initiative is, the question is does the spirit of number 3 mean the exact same thing as number 4? Because of a policy body has a different, they cannot pass an ordinance, so they call it an initiative.
It's not
instead.
an ordinance. It's by the initiative means it was created by. If you look up the normal.
Please have a seat. You haven't been called upon. You have not.
No, I'm calling this out of order.
You're doing a gray area, creating gray area where no.
I'm having a debate, so we can get to it.
Can I make a motion?
Go ahead.
And if you're not amenable to this, that's fine. But can we have a motion to continue this item and have the petitioner provide the language of the resolution that was cited in his complaint, because it's not in the body of the resolution is not in the minutes from the Arts Commission. Not that I should have had to look that up, nor is it in the agenda of the Arts Commission. And I think that it could be persuasive if we could actually see what the resolution says. The resolution that I would like him to provide would be, I have it, or someone else might have it, but on page 25, no. It would be resolution 0307-16-079, which was voted on March 7th, 2016 of the Arts Commission.
I would also request that the audio recording or the video recording from that meeting be included.
And should both parties produce the resolution?
No, because the reconsideration is from one party.
Mr. Chairman?
Yes.
I just like to state that it sounds like we're re-adjudicating this matter, and we're not just considering the new documents provided at this time. So I just wanted to put that out.
Right. So the point here is that the new information, we're giving the petitioner of this reconsideration the benefit to produce the new information, which would be the actual resolution, the action item in its full entirety, plus the audio and or video program of that particular action that was taken by the Arts Commission.
Yes.
That would be the missing information, because we're trying to interpret things based on hearsay and circumstantial evidence, okay, and not on the actual facts that happened. Yes. So that's what we're asking. That's what member testifies
Yes.
motion is asking for. Is there a second to that motion?
Second.
So moved by member testifies, second by Vice Chair Hyland. Okay.
Comments?
I'll get that. 1 second. Okay, Mr. Clark, I'll give you some time to speak on this as rebuttal, what you want us to consider.
Thank you. First of all, what you're asking, what is on that agenda in those minutes is all that the Art Commission did at that meeting. All they did was have that caption of what to vote on. There was no discussion that took place. They just voted on it because all they did was approve the working plan and the feasibility studies made by Kate Faust. So I'll do what you request me to do, but I assure you that all that's going to come back is that statement that was made, and therefore that isn't the case. What I'm saying is there is no gray area here. You keep implying that when a policy body creates a policy body, that it has to report back to the policy body. In this case, the process is that the working group reports its recommendations to the staff. Any changes that get made go in front of the Street Arts Program Committee. That's that's composed of 5 committee members, art commission members. That's the policy body. Whatever recommendation comes out of that committee goes in front of the full arts commission for a final approval. So the process is that the working group, after it was created, was supposed to conduct these meetings in secret, and but it was a tape recording of the meeting that was destroyed, was made to be destroyed, not a video. But that the working group, anything that came out of the working group was to go through staff, go to the program committee first, have a public hearing there, and then go in front of the full arts commission for final approval. Some of the items that came through this working group did not even go through the committee. It was put into effect by the staff on its own without any approval. But some of the things went to committee, were approved by the committee, and then approved by the full arts commission. So what I'm saying is your ordinance only says very clearly that it's any advisory board, commission, committee, or body created by the initiative of a policy body. It doesn't say that the new policy body, the advisory board, has to relate back to the full arts commission. It doesn't say that in here. It just discusses how it's created, not the process of what happens afterwards. And what I'm saying here is that this can only be a policy body because, as he stated, they claimed it was created by the committee. I proved it was created by the full arts commission, and it is an advisory committee, so therefore, by implication, that makes it a policy body. And, I will honor your request if you give me a continuance.
Okay, let's call public comment.
Robert Clark. I just want to make a couple of things clear. At the last hearing, when my brother and I came here, we were under the impression that because you said during the hearing, you, Mr. Wolf, said it specifically. First of all, you yourself said it was a policy body. And you said that even before we presented the new evidence at the last hearing. You already ruled in your own personal vote that it was a policy body. Secondly, we presented this evidence at the last hearing, thinking that, we were getting this reconsideration hearing at the last hearing, and that we must present our new evidence at that hearing. That's why we presented all the evidence, those documents from those other hearings, at the last hearing. We didn't come in. We were told by you that this meeting was going to start at the point where the vote was taken, that you were going to rescind the vote, and that all the committee, all the test members, you informed them specifically to vote for this reconsideration at the last hearing meant that you felt that the evidence we presented at the last hearing was sufficient enough for you to decide that your previous vote was incorrect, and that by voting for a reconsideration hearing at this time meant that you were going to vote to reconsider and change your vote. So now we walk in here at this time, and then all of a sudden I'm being told I've got a hearing de novo. We've got a hearing de novo where we've got to present papers that we presented at our first hearing, papers that you personally read at the previous hearings, which made you decide personally that, yes, this is a public policy. This is a policy body, not a passive body. That's why you were one of the minorities that voted it during the first hearing. Now I'm getting the impression that by presenting more evidence, now you're acting like you're not sure whether it was a policy body or not anymore. You voted after our first hearing that you were sure that it was. We're presenting more evidence at the last hearing to establish that the working group did advise the Art Commission, because the Art Commission was saying they didn't advise us. Oh, they were we were just taking their word, and we were just having a focus group, and we were doing this and that. But they, in their papers, they said it wasn't an advisory body. We weren't taking recommendations. We presented their own documents that showed that they were getting recommendations from the working group. They were acting on those recommendations. As a matter of fact, some of the members of the working group were helping them to implement those policy changes. You read those papers that we presented at the last hearing, all that evidence. We were under the assumption that that was our hearing at that time, and those comments you made at the hearing meant that at this time you were going to change your vote because you felt the evidence we presented at the last hearing was sufficient to change your vote.
Ready?
Yeah.
Hi. Okay, members of the task force. The previous file was 17009. I looked through it. There was no resolution. There was no new documents submitted between that file and the hearing today. So the bar that you talk about of submitting new evidence that would have changed the outcome of the vote on this file was not submitted. So I think it's very magnanimous of you to continue this so they could get their paperwork in order. I think it's a faulty record keeping on the part of the Arts Commission not to have their resolutions on file or online or easily to get to. I could spend 20 hours fishing through their agendas and to try and get to that, then I would have to go to the clerk of the court and I would have to actually pull up the resolution or the motion number. It's a very time-consuming process. But for what I remember and I recall was that these were closed meetings. I did actually go. I tried to attend. I cited barriers to attendance prohibited, and I was told they would call the police if I stayed there. So that's my personal experience on it. The notes were written by Ann Trickey. She was the person who was here last time. And any audio that may have taken place or may have been destroyed was between street artists and some sort of cat fight. So, you people can do what you want, but I think on this one issue alone tonight, spending an hour and a half debating this is crazy. They should have had their paperwork in order.
Any other further public comment?
Yeah, I just would like to have it out in the open that part of the sensitivity here is that street art is considered by many an illegal or an improper activity, and that there is a compelling public interest in maintaining a sanctuary, if you will, around advisory or fact-finding or focus group, and I'm something that the chair of this task force is well aware of as an artist himself. With that in mind, there is precedence in San Francisco for creating these types of bodies and closed task forces that can act as a barrier between discussions between street artists and the Arts Commission, going back to the needle exchange programs of the early 90s when the Board of Supervisors had to make certain findings amid the health crisis of that time. And more recently, you might find that in the context of safe injection sites. It would be helpful if the Arts Commission could publicly state why they're doing this. But there is probably information that should be known to staff, not necessarily to the Commission directly. Certain names can be discussed that can actually be used against certain practitioners of street art, and creating a safe environment to have certain practical policy discussions is probably good public policy, and I'm sure that you could find somewhere in the Sunshine Ordinance a statement to that effect. Thank you.
Just for the record, to correct the last speaker, I am not an artist. There are 3 Bruce Wolfs in the Bay Area that are notable. One is the artist that has done most of the busts here in the city hall, and that's not me. Okay, so I just want to clarify that this is exactly the hearing. This is not the petition for the reconsideration. This is the actual hearing, and it would be at the place just before we took a vote, which was to determine that this working group was a passive meeting body. Okay, the question is whether that motion should be rescinded, a new motion should be made, or whether it should be amended at that point. Should a different motion be on the floor? That's where we're at, okay? So this is as if we've gone through the opening presentations, 5 minutes for each party, the witnesses, and rebuttals. We're beyond the rebuttal part, okay? So, with that, are there any other questions? That we have some interest in seeing the actual information. Okay, I'm gonna, if Ms. Patterson's still here, I'm gonna ask her, since she's here on behalf of the commission. Can you come to the microphone, please? Oh, here, come. I'm gonna ask, how is there a formal written resolution, an action item that the commission passed that's in writing that creates this program?
Based on what we've written in the past, and I don't know the resolution number by heart, but the way it would have occurred was it would have been voted on at the Street Artists Committee level, and then it would have appeared in the consent calendar at the full commission meeting. So any supportive documents would have been made available for the committee. Anyway, I'm going above and beyond. So I believe that, yes, it was, they approved the work plan.
Was the work plan presented? Like, I see what has been, what's in the record, and what's in the record is I see notes from working group. I see a proposed plan.
I'm sorry. So we're just starting from scratch now on the whole thing. Is that what we're doing? Or are we continuing it and allowing him the opportunity to bring the new evidence and then starting the hearing? I'm confused.
That's to be determined. I mean,
okay.
The process is we have the hearing. One or the other parties is not satisfied with the outcome of that hearing. They file for a petition for reconsideration. The reconsideration is either approved or not. If it's approved, then the item is, the hearing is as it was from the start, just before the vote of the motion that was on the floor. The motion that was on the floor at the time was to determine that this working group was a passive meeting body.
Okay.
So that's where we're at. And the questions that are before us, I'm sorry, go ahead.
Can I also add that we should only be taking into account the new information provided and not re-adjudicating the previous portion?
Well, no, the new information is added to the case. So it's now part of the new case.
But I believe that should be the primary focus, is whether or not that new information would change your mind.
I hear what you're saying, but in standard parliamentary procedure, when you bring a reconsideration forward and a reconsideration is approved, then it goes back to the point of just before the vote is taken. And if there's the opportunity, what we do is we provide the opportunity to bring new information and make it part of the record. So that way, the whole case can be considered with the new information. That's how reconsideration process works. So again, the question I have for the commission, the Arts Commission, is there not a proposed document, but a real, like, formalized document that was presented to the commission? Like, what did they see in order to make a determination
So,
on this?
Victor, can you turn the overhead on for me just a minute? Or, sorry. Okay, I apologize. Okay, so, okay. Well, this was presented at the first hearing, so, so we had presented at the last time we met this timeline we prepared for you per your request of the series of events. And in this first item, you see the work plan and project scope for modernizing the Street Artist Program was presented for public comment and committee approval at the Street Artist Committee meeting. An excerpt from the minutes is provided below, and then it included 2 links. So if you want, I can just pull that up and you can see what the actual supporting documents were. We also included a link to that. Would you like me to do that?
Just hold it there.
Oh, sorry.
Don't move it around.
Okay, sorry.
Thank you. I just on procedure, I want to ask that the previous motion for continuance be rescinded or tabled for the moment.
I'm amenable to that.
The seconder?
I didn't second.
It was Mr. Highland.
Oh, would you agree for it to be tabled?
Sure.
Okay. Is there any public comment on tabling the continuance just right now so we can continue with this line of questioning?
I have
on the continuance only.
On the continuance.
On the tabling of the continuance.
Your words, not mine. This was a hearing. The documents should have been provided. The complainant had ample opportunity to provide new information. It's right there. That's the definition of a reconsideration. This is not in the file. You have a mishmash of maybe, I don't know, let me give you some generic nonsense. A motion has a motion number. A resolution has a resolution number. You go, you pull it up. It's there. It should have been provided. It should be in the packet. Everybody should have it, and there should be a reference. There should not be this ongoing nonsense. To give them time so she can maybe and if and not present documents, and you can gyrate through this again and again and again. I have 3 complaints. Do I get to hear them in a minute and a half? It's just not equitable. None of this. Bad record keeping, no documents, and you have a very clear ordinance, very clear specifications as to what a rehearing is. If this were the Board of Permits and Appeals, you would get 3 minutes. Boom. End of story. Your documents are there or they're not. There's new evidence that would have changed the outcome. It's not this nonsense.
Thank you.
Robert Clark. Bruce, what was the specific... You said public comment on a specific...
On the continuance, tabling of the continuance.
Okay, tabling the continuance. I'm going to object to tabling the continuance because I explained to you that we were under the impression that we were presenting the new evidence at the previous reconsideration hearing. We were under the impression that by comments that were made, that by voting to have this hearing, that it was in effect that the new evidence that we presented at the previous hearing meant that the members of this task force felt that the new evidence was important enough and changed their position enough to have a new vote, to change their vote. So now I'm being told that, oh no, we have to have all this specific information. So I'm requesting that there be a continuance of this till the next hearing, and we'll present this other information to you. But I want to make it clear that we are under the impression that this new evidence was presented at the last hearing, that the members of this task force looked at it at the last hearing, were convinced that it was enough for them to change their votes, and that's why they voted for the reconsideration hearing. So So, maybe it's a misunderstanding on our part, but we thought that our last hearing was the hearing in which we were mandated to present the new evidence, and that by presenting it at the last hearing, that would give this task force ample opportunity over the month to 2 months that we had since that hearing to look over all that information in those documents that we presented, showing that the working group was an advisory group, and therefore that was the only question at that time that had to be answered, because we had been under the assumption that it had already been determined that there was no doubt that the full R Commission initiated the working group, and that question had been answered. The only other question was whether or not this new evidence proved that the working group was an advisory group. So therefore, I'm requesting that you continue this for till the next hearing, so that we can provide the other information that is requested.
So I just want to say that I hear what the last commenter said. The purpose of the reconsideration is to provide new evidence that may compel a change. It's not a guarantee. It's not no doubt. There are, on here, there's 10 members that can reconsider their vote or their position on it for whatever reason. They read it with the new information, they get some new light on it, now it means something else, or it means the same thing. That is the purpose of this process. It's a deliberative process. It doesn't just automatically mean that because new evidence has been presented, and even if the evidence has been accepted, that it automatically means that the vote will change. And I've kept asking throughout this hearing if there was to be a change in the motion. Okay? And what we've got was a request for a continuance. Now, I've asked, the motion that I'm asking for is to table the item just for the moment, so I can, because we are back now in the in this regular full hearing with this new evidence now included. Now I'm asking for some additional questions from the petitioner as to where this information may exist, because the petitioner has testified that it was not much was there, that it was just presented without any materials. So now I want to find out if there's any materials there. So I'm asking for a little extra time before this motion comes back to continue the item, so we may be able to maybe ask for more information that would help lend to the outcome of this case in the future, at a future meeting. So, with that, and I am not asking for any more comment. At this
I thought
time.
you were pointing.
No, I did not point to anybody.
You said you were asking.
I
the
just
petitioner.
made a outward. I was referencing.
Understand. Now you're correcting yourself, but
I
you
am.
did say the petitioner.
I referenced the petitioner.
So I thought you were going to ask me where that information came.
You had testified to that already.
Can I move the table, or does it have to?
No, hold on a second.
I think we've already agreed on that. We've taken public comment.
Right. So I'll ask for. Can somebody second the table?
I think
It was.
No, it needs to be a formal motion to table.
It was. Member Tesfa seconded by.
No, that was the actual continuance.
That was the
I
table.
was withdrawing. He's asking me to withdraw my earlier motion, and then he also asked Member Highland to withdraw.
Okay. Motion
Right.
to table.
So I wanted to move to table this. So I make the motion. I'm making the motion to table.
Second.
So second by Vice Chair Highland. We just have public comment on that item. Yes. Yes.
Define table, meaning it goes away?
No.
Comes back?
Table means that just for this meeting, we're asking to delay that motion. I intend to take it from the table within the next 3 or 4 minutes so that we can vote on it. But I want to ask some additional questions. I can't do it in the confines of that particular motion. Okay?
Do we need to vote on that or not?
Yes, can we take that by acclamation? Seeing no objection. The motion to table the continuance is approved. So now I just need 1 minute to look at something. All right, Ms. Patterson. So I'm looking at just so I know what to request from you.
Okay.
I'm looking at the minutes of February 18th, 2016.
Mm-hmm.
Okay. And I see a hearing, number 3, hearing and possible motion to approve the work plan and project scope statement relating to Kate Faust's evaluation of feasibility study reports. Is that it?
Yes.
Okay.
And I just put on the screen an excerpt from those minutes.
All right. Okay. Okay, fine. So that's I'm clear in what we're asking for. Okay, so I move to take from the table with a motion to continue this item. Is there a second?
Second.
So moved by Chair Wolf, second by Vice Chair Hyland. Is there any public comment for raising from the table?
I support raising it from the table, and I will support the motion to continue till the next hearing.
Any other public comment? This is just on the taking it from the table.
This is a waste of everybody's time.
Thank you. Any other public comment? Seeing no public comment, can we take this by... What? Is there any other public comment? Can we take this by acclamation? Okay.
I want to vote no.
You want to? Okay. Call the roll.
Sorry, what's the motion?
This is the table.
This is to take it from the
I'm
table.
fine, acclamation.
Okay. So seeing no objection.
I'm sorry.
The item is now back in play. The motion on the floor is to continue the item with the request for the written resolution and any audio or video recordings of the meeting. Okay. We've had sufficient public comment on this item. Yeah.
I thought from what Ms. Patterson Murphy said was that the item may have appeared on the consent agenda because it was already on a committee agenda.
Yeah, but it's actually, I did due diligence to look at the minutes, and it wasn't. It was individually discussed in length, and it was voted on not in consent.
Okay, then I agree with what you're saying.
Okay. Great. Okay. So
We've already taken public comment on continuance.
Not on the new motion.
On the continuance.
Not on the new motion.
It's not new. It was.
You took it off the table was the motion. Now you're making the motion.
No, the motion was already on the floor.
Just revisiting.
We tabled it and then brought it back. We've gone through the entire process.
Okay, I have a question of clarification. When you say you want these papers, and do you want the entire Faust working plan and the feasibility in its entirety for us to present that at the next hearing? Because we can get that if you want.
We want resolution number 0307-16-079 that was approved on March 7th, 2016.
It'll be in the minutes.
I will provide it to you at a later time.
I'm tired of being harassed by her.
All right. All right, can you call the roll on this, please?
Can you read the motion?
On that motion.
Please reread the motion.
Continue.
The motion is to continue the matter to the call of the chair, and it's a request for the parties, for the petition to provide a copy of resolution number 030716-079, plus any related audio recording from the approval of that item on March 7, 2017. On that motion, Member Kanata.
No.
Kanata, no. Member Fisher.
Come back to me.
Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon.
Aye.
Eldon, aye. Joshua Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
No.
Moss, no. Member Fisher.
No.
Fisher, no. Chair Wolf.
Aye.
Wolf, aye. The motion fails.
Okay. There any other motions?
So, can you just clarify where we're at?
So we're at the full hearing. We have come to the point where we've heard testimony from both parties. We've heard testimony from any witnesses or other persons to provide facts or evidence. We've done deliberations. We've heard rebuttals. We have added in evidence that was provided to us, new evidence that was provided to us at the reconsideration. And there was a motion on the floor to find that the working group was a passive meeting body. That's the motion on the floor right now.
So I will move to find a violation of 67.5 for not being a policy body, not having meetings that are open to the public.
Wait, we already have a motion on the floor.
Oh, sorry, we do?
Yeah,
so
I
apologize.
The maker, actually, the maker or the second can rescind it, or it could be a motion to rescind it, or it could be amended.
So this is prior to this is the one that's on.
That original motion was, the mover was Vice Chair Hyland, seconded by Member Hinsey, to move the fine that the Arts Commission violated Section 67.4A by failing to make a passive meeting body accessible to individuals upon inquiry. That motion was adopted by the task force. I believe we are prior. That question is before us again at this time.
We are at the point just before voting.
Okay, so the appropriate procedural thing is to make a motion to amend the motion?
You can amend the motion, or you can ask for it to be rescinded.
Member Hyland, would you be open for rescinding?
Well, let's. I might be open to changing the motion, like changing the code. What did you have in mind?
So I was suggesting 67.5, which requires meetings. All meetings of any policy body shall be open and public and governed by the provisions of the Ralph Brown Act. So that is what I figured would be the cleanest way to handle the.
I would accept
violation.
that. That gets the passive meeting body language out of it, which I support that.
Point of order takes precedence, so just say
Did
it.
I miss something? When did we declare that this was?
We never
At
did.
our last meeting, we made the motion. However, due to the reconsideration request, the vote has been nullified, and that motion is still on the table at this time.
It's not necessarily nullified. The whole process comes back to the point of just before we vote.
Okay.
That's how
So
in Robert's rules, that's how
I get that part.
reconsideration
The
works.
clarification I'm asking for is, if we're of the opinion that this is just a passive body, which way would
I
we
believe
vote
we
on
need to
this?
finish the motion in second before we can answer that question.
When we have all these motions, will somebody please clarify for me?
No, let me just clarify. The motion that's on the floor, just
go ahead.
before,
Motion will-
just before Member Moss had requested a change. The motion on the floor is, read it.
The motion on the floor was to find a violation of Section 67.4A by failing to make a passive meeting body accessible to individuals upon inquiry.
Okay. That's the motion on the floor right now. Now, we could move to a vote, or somebody can make an alternate motion to either amend it or ask that it be rescinded.
I believe that Vice Chair Hyland has agreed to a proposed amendment by Member Moss to change that to a violation of 67.5 to read that a policy body violation occurred for not making their meeting open to the public.
But they're not a policy body.
That's where we need to debate on that now.
We can take a vote on that.
Is there a second to change that? Does the second agree to that change in the motion? That would be Member Hinsey.
Wait.
Okay, so
like our
let me just try to explain. So at the last time around, we thought we were all okay with passive meeting body, and we voted 6-3 to go with that.
I
Now,
just need clarification. What we're changing it to?
To policy body.
so now some of us are thinking it was more than that, and we're going to try to take a vote on that.
All right, so wait a second. If you're going to, are you rescinding the original motion?
No, I'm changing it to 67.5.
So wait, then it's got to be in the form of it as an amendment.
It is. And we're waiting for Member Hinsey to...
No, so are you making a formal motion yourself to amend this this item?
That's already been done, and it's...
No, it's not.
It has been.
No, it's not.
So I asked whether you would be willing to rescind it.
I said
and
I
he said
was.
he'd be willing to amend it. And so we need to clarify whether
Somebody
I'm
has to
making
make a motion to amend.
or if you're going to rescind it, and then I'm going to make a motion on a fresh amendment, right?
That's correct.
All right, and we were looking for Member Hinsey.
No, somebody has to make a motion to amend.
I'll tell you what, I'm going to make this easy. I will rescind my original motion.
There you go.
Okay.
And the second has to also agree to
Do you
that.
agree to rescind?
Sure.
Okay, so the motion is rescinded. There is no motion on the floor. Now, is there a motion?
Yes.
Okay.
So before I make the motion, I want to say that there it's possible that there are more violations here because you'd have to go through all of the meetings. That if we find with the 67.5, we would have to go through and find all of the possible things. I think the cleanest way to go about it is the 67.5 violation that I'm about to propose. So I move that we find for a violation of 67.5. Regarding meetings by policy buys must be open and public.
Is there a second?
I'll second that.
Nick?
It's been moved and seconded. Any comment?
Yeah, I have a question for
go ahead.
DCA COLA. So if we feel that this is not a policy body, then one would vote no on this. Is that correct?
That'd be the way to go.
Okay, thank you very much.
Okay, I do not agree that this is the appropriate section of the ordinance to cite as a violation because the question before us is to determine first whether this body is a policy body or not. First you have to determine whether it's a policy body before you can show that there's been a violation. I'm not convinced I'm not necessarily convinced because of the new information that was provided and the fact that some additional, I want to see the original and official record that was approved so that I can be very, very confident about how this was passed and what the intention of the commission was. Now, I could be very much in agreement that it is a policy body, okay, but right now, revisiting this entire thing, I'm not convinced. I've changed my mind. So that's where I'm at. Member testify.
I feel the same way. I am open to the idea that it could possibly be a policy body, but without having looked at the original item that I had requested that they produce, I would not feel comfortable voting on that.
Member Eldon.
Wasn't part of the thing that we talked about before that they had acted in a way that was like a policy body, not just that they've been created in that way?
There had been some circumstantial evidence that would show that might be true, but the ordinance requires that you look at how the body was created. And that's why I need to see the document that created this, whatever it is.
Member Kanata, then Member Moss, then Vice Chair.
Just to clarify, a lot of verbiage has been spent saying that this is an advisory body, therefore it's a policy body. That's not true. A passive meeting body can be an advisory body. Okay, so just so that's out there, because the complainant has continually said that it's an advisory body, so it has to be a policy body.
Member Moss.
So one of the reasons that I voted against the motion to continue is that I did not feel it was appropriate to put that on the petitioner to file another public records request to get documents that we should be able to get pretty easily from the respondent. If that's just my personal opinion. Now, I also believe that the same documents that they're going to now be provided are the ones I'm looking at on my computer right now. So that's kind of why I'm still.
But they're not in the record, right?
I mean, the way that they were put, I mean, we have letters from the San Francisco Arts Commission saying, here's where you go find the documents that we're referencing, and that's what I'm looking at. Now, they maybe they weren't, but the links to them were. So, but we seem to be asking the respondent here that he has to go file another public records request to go get stuff to prove his case again, where I don't feel like we would be doing that normally. We would say, hey, at the committee level, this would have been assembled, or we would have told the Arts Commission, hey, you're saying this is when we decided when we had a vote on whether this was a passive meeting body, we didn't demand that the Arts Commission come bring this resolution and to show it to us. We voted on it and we had that vote. Now we're saying that is not the case. So, I don't know how we can vote on the previous amendment either, because we don't have that resolution still. And I feel like that this should not be on the petitioner, that if the Arts Commission's position is that this is a passive meeting body, they're responsible for providing the resolution to us.
And you may not have thought about it before, but could have amended the continuance motion to say that anybody provide it. Right. Okay.
But I mean, we make another continuance motion. So
right. Go ahead, Vice Chair Hyland.
I was just going to say that we've a lot of this discussion has been around the code, which is definitely interesting. But if you just to roll back and take a 30,000-foot view of this, I just think this process was not open enough. I think we need more sunshine. We should always err on the side of sunshine. And my instinct has always been to rule on that side. That's why I think the strongest message we can send this body and any other body is that this was a policy body. And just to kind of nip this in the bud, set some precedent. We've put a lot of time into this, and I hope this motion goes through.
I have some questions with regards to the interpretation of the ordinance because of the way it's written. And the question is regarding the word initiative of a member or of a policy body versus how whether that is meaning to be the same thing or not as what is described for the Board of Supervisors as with regards to an ordinance and resolution. The question also I have is with regards to the creation of an advisory committee. If it's inclusive of a program, is that the actual creation of an advisory body, or does it have to be named? Does it have to be singularly named so that there's like an active focus on that advisory committee? So if the word initiative, as the framers had created it, was meant to mean the same thing as an action to create a particular body, that has very specific meaning to me versus, I mean, in other places like the Department of Elections, the initiative is something that goes on the ballot. How does that? It's got multiple meanings. So I want to be very, very clear so we're fair to both parties and we're fair to the public, because by just saying that this is a policy body out of expediency doesn't serve anybody. Okay, I would prefer to continue it, and so we can have further deliberation on it and have more information on it, so we don't make a mistake. Because otherwise, that will resonate for years to come until the law gets changed, if it can or will be changed. So we're in a place, there a motion?
The motion was made and
Oh,
seconded.
right.
Public comment.
Repeat the motion again?
The motion is to find a violation of 67.5 and determine that the working group was a policy body and they failed to make their meetings open and public.
Okay, great. So let's have public comment on that.
Robert Clark. I support the motion. I want to make it clear to the gentleman over here that we have not been just saying this is an advisory body or an advisory board or an advisory committee. We've been saying it's an advisory board, an advisory committee that is initiated by a policy body. We're saying it's a policy body that's been initiated by a policy body. Those are the two things that we need to have for it to be a public policy body. So we're not just saying because it's an advisory body that makes it a public policy body. We're saying that it is also because it was initiated by the Arts Commission. We're also saying that the San Francisco Arts Commission is running this the Street Artist Program, which is made up of art commissioners, which is supervising the Street Artist Program, which is overlooking the working group, and therefore the working group is responding to the Art Commission, and the Art Commission is responding to the working group. And I want to say that it's obviously the definition of initiative that we're discussing here is not what's put on the ballot. That's an initiative. It's called an initiative. What we say when we're saying it's been created by the initiative, look up the dictionary definition of initiative. It means created by, started by. That's the term initiative as it applies in this case. So therefore, because of those things, I support the motion that this was a policy body created by the Art Commission, a policy body. Therefore, it's in violation of Section 67.5 because it did violate the Brown Act. It did violate the Sunshine Ordinance when they held their secret meetings, did not have any records of what happened, refused to let people tape record the meetings, told people they were not allowed to attend, even if they were just going to sit in the audience. All these things are governed, are told that policy bodies must adhere to. And as the Sunshine Ordinance Task Force, this, if anything is a clear violation of the Sunshine Task Force, creating this body, this secret meeting, which kept people from going to, they were kept from going to, and then they initiated these policies. I mean, I don't see how it can be any clearer that this is a violation of Section 67.5. So I support the motion.
Is there any other public comment?
Through the chair? Sorry, there's more public comment.
You must have some idea by now how fractured the Street Artist Program is. You're forced to sell in limited selling areas, and on Beach Street, where these two sell, it is unbearable. Nobody talks to him. Nobody wants to be around him because these kind of discussions that have taken place now over the course of an hour and a half take place out on the street when you're trying to work and make a living.
Any other public comment? Seeing none, Member Moss.
All right, so I am hearing you, Chairman, that you're concerned that you may have a bit different decision if you were to spend more time looking over meeting minutes, agendas, the documents that would be provided, and that sort of thing. Is that correct?
That's correct, because they're not part of the record.
Okay, well then in that case, I think I'm going to. Sorry, I'm
just annoyed that I had this motion 30 minutes.
I mean, I'm sitting over here looking at stuff that I want to read out that I feel like is convincing, but I don't know. I mean, I don't. If folks would rather spend more time, then I guess so that I can rescind the motion. I feel like I have enough and I feel like we've gone over this enough that I think that I feel confident in my vote. But if other people are wavering and are going to move in a different direction just for lack of knowledge, then I'm willing to rescind my motion.
Or you could just continue. We can just continue
the motion and the case.
And it just picks up at that.
With the same motion?
Well, it would, but we need the information.
Yeah. If we don't include what I originally asked for, I don't want to continue this anymore, unless we have the document. Unless we have the document that created the resolution that I asked for almost an hour ago, then I don't want to continue this item.
Yeah. So, in the event the resolution doesn't exist, and it doesn't exist beyond what's already in the record, that's fine too? Because
I'm not necessarily going to vote for your motion. I need to see either need to see the document or this needs to go away.
That's fine. I just want to be clear if we're giving people instructions, because when I went to the agenda for the hearing that the Arts Commission had, all they did was link to the Street Arts Committee's agenda, which had the link to the same documents that I showed before. It does not seem like there was any formal resolution written out or presented to the committee.
Right. So let's just be.
We're getting back to that's fine.
Let's just be clear. When you look at any other commission's agenda, okay, they have the actual documents that apply to that motion or that action. Okay, it's not referenced to be somewhere else. It's included in the agenda. It's supposed to be. It's actually part of the Sunshine Ordinance that those documents be attached to the agenda at the time the meeting commences, and that a number of copies need to be made for the public and needs to be available online, so on and so on and so on. So the point, that's kind of where I'm at here. If all that is missing, and all I have is a proposed work plan, and that's all I got to go on, and with all the additional comments and information that was provided, I want to make the right decision. I do personally. I want to make the right decision.
So in that case, the things that we're looking for are the resolution or what served as the resolution, right? Like we're not going to hold it against the respondent if he comes back and says, I filed a public records request and they gave me nothing. That's not like all they did was link back to what they had before. I don't think we should hold that against them because they weren't able to produce a record. I think that we should be looking at listening to the recording. I think we should be looking at the minutes for both for the Street Arts Committee in addition to the actual Arts Commission, because it was, as noted by Ms. Patterson, it was a consent calendar item.
It's not.
For the Arts Commission? I mean, I'm looking at the minutes here.
I'm looking at the minutes, and it shows that it's not.
Okay, so it showed it was discussed, because I'm looking at the Arts Commission, the Street Arts Committee, where they discuss exactly the creation of the group.
February 18th, 2016. Is that what you're looking at?
So that is the Street Arts Committee. That is not the full commission.
Okay.
So if you're looking at the minutes on there, then you'll see a paragraph right before the vote that describes what the group is and what it's supposed to cover, and that's the sort of thing that I feel like should be discussed.
Okay. But I want that to be in our packet. I don't want us to have to go on a treasure hunt to go and find that stuff. That's not our responsibility.
That's fine. I feel like the Arts Commission provided links to these things rather than provide them actually in their submission to us.
Is there a motion? So we have
There's a motion on the table.
What do you want to do?
So, I mean, if I continue it, does the motion still exist when
you would need to rescind your motion, I believe, and issue a new motion?
No, you can continue this meeting. We just pick up at the point that this motion is on the floor.
With the documentation we need.
The question then becomes: we can make another motion.
Okay.
The question becomes, if we can continue it and ask for this information. Okay, we come back in a month or whenever this will be rescheduled. We pick up at the point where we are right now. We have that information. We can table this item so we can discuss everything. If you want to make it clean, you can rescind the item. It's up to you. You're the maker of the motion. Either way, it'll work. Either way.
That's fine. Member Harlan, do you lean towards?
I think it'd be nice to have a motion to start with because it'll at least capture the work that we've done so far, and we're pending certain documents, which, if they're together, we can move through this.
Okay, so when we come back, this item will be at the point we are at right now, just before the vote, okay? We will table the item again so that we can review all the information, okay? And we'll pull the item from the table when we're ready and decide what to do at that point. Clear?
Okay, so I'll move to continue.
I believe the motion would be to table the motion and to continue the matter to the call of the chair with a request for certain documents. If you could list those documents for me again.
I will not, no, you not table, because if you table it and this meeting ends, that disappears, okay?
We're continuing.
So just do the continuance.
To continue this matter to the call of the chair and to request certain documents, and if you can provide that list again.
Okay, so that is going to be the supporting documents and resolutions approved by the Street Artists Committee, and the San Francisco Arts Commission. Recordings of the discussions by both committees on those items, and the minutes for both of those items. Is that correct?
Yes, and who do you want to provide that information?
I think that I would like the San Francisco Arts Commission to provide that information.
Okay.
I think they're all within their open meeting issues. So.
And the plan will be for all of us to watch the video during the meeting?
I mean, I would hope that we could watch it all in advance, and so we could skip that. But
video recorder.
Audio.
I believe,
Their audio.
May I suggest that I get the link, provide a time stamp to each member, and you can listen to it prior to the meeting.
That's fine.
Yeah.
It was just a question. I'm just wondering how you guys
You
want to
just said
proceed.
there is no audio either.
If there's none, there's none.
Let's let Ms. Patterson answer that.
Ms. Patterson, can you respond to video and audio of the
There
commission?
is audio, there is no video.
Okay.
Of
There you
both
go.
committees? Of both the commission and the Street
Only
Artists?
audio for both the committee and the full commission.
Very good. Thank you. So audio.
I will get the audio link from the Arts Commission and provide a timestamp of the start of that discussion of that specific item, and I would request the members to listen to it before the meeting. I will also provide that link to the petitioner so that they have the same information.
Absolutely.
Very good. Would that be for both meetings?
Yes.
Thank you.
Right. Okay, great.
So moved, I
Okay.
guess.
Is there a second?
Second.
Moved by Member Moss, second by Vice Chair Hyland. Public comment.
I
What's that?
totally missed the motion already. Can you say it again?
One moment. We're just going to repeat the motion.
No, I remember.
Motion is to continue and to ask for a number of items. Okay, got it.
I support the motion to continue, and even though you're requesting the Art Commission to provide this information, my brother and I will also provide the information, and we'll provide it to the task force, to the clerk of the task force, with ample time so that all the members of the task force can peruse it at their own leisure, and so they can get a better idea of what actually took place during those hearings. I support the motion to continue.
Is there any other public comment? Seeing none, public comment is closed. Please call the roll.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Yeah, come back to me on this one, too.
Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon. Aye. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
You called me first twice there, Victor. I wanted to go last.
Okay.
Yeah, you.
All right, thank you, everybody, for your indulgence on that. And I'm glad we got this on track.
Next on the agenda, item number 8, file number 17019, complaint filed by Anne Chabot against Howard Lazar and the Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a complete and/or timely manner.
Okay, this was heard in complaint?
Mm-hmm.
Okay, so let's get a summary from the complaint committee chair. Member testify.
Yeah, so we heard this item. What we learned there was, sorry, let me pull up my notes.
Exactly.
Sorry, 1 second. Okay, so in this item, it was an immediate disclosure request. The Arts Commission said that the email address, because it came from an AOL email, it went to their spam, so their late response was because it went to their spam. Because it's an AOL address, that's the main information. We, of course, don't make a recommendation, but, it doesn't matter what kind of email address that people have. You are still the agency is still responsible to respond in a timely manner. But I probably shouldn't have even said that. So, but yes, so it was an IDR. It went to the Arts Commission spam because of the type of email address and was not responded to in a timely manner.
We found jurisdiction?
We did find jurisdiction, yes.
Yeah. Okay. Everybody ready? Ready? Okay.
Ready. Page 187 is a timeline. It goes through the dates. The claim that they're going through some platform or this isn't going to happen ever again is absolutely not true, because the exact same thing happened 2 weeks ago. Not to Howard Lazar because he's not there, to somebody else. And then there's all the bizarre undertones, yada yada, that I'm doing it on purpose and moving forward and they're going to fix it. That's all nonsense. And then we also know on page 188 that Kate Patterson loves to shift blame, and she very often says, oh, it's the IT department. Well, the IT department is right here on this floor, right across the street from their office, and we know from previous hearings that when the IT department was in here at committee, that the Arts Commission never reached out to them. So, yeah, this is a violation of 6725, but it's also a violation of 6721B because they never invoked an extension. They never really did anything. And, of course, I never got the documents. And once again, what I got was a link. I was asking for specific information because they recently changed their policies. And it at the time was very important to me. And what I got was a link to their original agenda where you see it on page 200. Once again, a link where I've already looked at this information and said this is not relevant information. Please supply me with updated screening criteria. They didn't. So I didn't get the documents that I requested at all. And it wasn't only to me, it's to many people. If they're changing their screening criteria, well, people need to know, but we don't get to know. So that's it. I look at it as 6721B and 6725A. And there's really no excuse, and it's still going on. And that's it.
Thank you. Are any persons or witnesses provide any facts or evidence on behalf of the petitioner? Seeing none, Ms. Patterson, 5 minutes.
We can see that we were late, so that's, we admit to that based on the last hearing and the fact that it did go to our junk mail. And we have discussed this at this body before, that there are issues with AOL accounts being delivered to our junk mail. And but what I failed to mention the last time is, since we had this issue, all staff was directed to implement rules so that anything with IDR, immediate disclosure requests, and variations of that is immediately delivered into my inbox, no matter who it comes to. So this complaint dates back a while back, so we have since implemented that for some time now. We did give her the records when we were made aware of the request. We did respond fully, and we gave her the criteria she requested. There was no other criteria at the time, so her claim that we did not send her the right document is just not true. We did provide her with a document, so I have nothing really further to add.
Thank you. Are any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members?
I have a question for Ms. Patterson. The documents provided, were they a link, or did you actually give a document?
I just have to refer back. It should be noted that we also asked her to clarify some things, and I don't believe we had clarification. And let me just see the criteria. I'm just looking for my original email.
Mr. Bell, did you get a document or just links?
Yeah.
I see my email. I do see my email. It looks like we did provide a link, and we also provided attachments as well.
I guess if you're doing it by email.
Yeah, so we did provide a link to the screening categories, yes. And there are many.
Could you put it on the projector? Is that possible?
Oh, sure. It's really muddled. I don't know why it printed out this way. It's horrible I don't know why it came out this way, but this is when I printed out from the packet from the website.
Bad driver.
But here, try to see here. So this is my original, here, let's try this. This is my email to her. And here is the link to the street art screening categories. And that, it is huge because with each category, there's like it just is very extensive. It's a very extensive sort of description of all the different categories. So really, the link is the best way to get the information to the person.
Did she request it as hard copy?
No.
Did you request a CD or DVD for it to be put on?
Did I request that?
Did Ms. Trevaux
I don't believe she did.
Okay. Thank you. Any other questions? Victor, is the original complaint in the file? I don't see it. The intake.
Give me a moment. It's usually in
Page 185, I think.
And 201.
201?
It's an email request to open a file. Oops. I believe that's page 185.
185.
It's an email dated March 21st, 2017. Please, in the subject title, it says, please open a file and schedule a hearing.
Oh, okay.
I never received a response.
Okay, great. All right.
I'd like to make a motion.
Go for it.
I'd like to make a motion to find a violation of Section 6725 for failure to respond to an IDR in a timely manner.
Moved by Member Tesfaye. Is there a second?
Second.
Second by Member Kanata. Any discussion? Public comment? Oh, we need to do rebuttals. I'm sorry. So let's hold that motion until we get to rebuttals.
Through the chair?
bad. Yeah.
They can do rebuttals to the motion as well. It's possible.
Yeah, I know, but just our process to wait until rebuttals before we do a motion. Ms. Patterson, you have 3 minutes for rebuttal.
I have nothing further to add. Thanks.
Ms. Gibault, 3 minutes for rebuttal.
This is classic Kate Patterson. Here is page 200 of your packet. This is the only thing I got, which are links. And I was very clear in my IDR March 3rd. I asked for updated screening criteria within the past 3 weeks. This is old screening criteria from more than 5 years ago, which has been on their website. And of course, the attachments are not in the file, and these so-called attachments, I would have to search to find what it is that she's including as these attachments, and that's what makes these things so voluminous. She did not send a clarification email the way she suggested. Where is the evidence of that? I have printed out the entire email string, and a timeline. The original email from March 3rd.
I know.
Onwards. And I also noted on page 198 with the screenshot of Howard Lazar, I said it at committee level, that there were other important emails that were in his trash, not his junk. And toward the upper left-hand corner is a box that you could check off that would delete it. He's already checked that off. I blew that thing up, and I saw a check mark in it. So, this whole aura that I'm doing this on purpose and I'm making fake emails to whatever my objective to her is completely wrong. She bombards me with so many annoying emails, it's near impossible to track, which makes these files unbelievably annoying. The burden is on the respondent to come in here with files and say, this is what I sent to the complainant. This is the day I sent it. It's not maybe, if, here's a mashup of a messed up email that I sent her. That email that she put on the screen doesn't look like this email. It's record keeping, this whole air of making up that I'm a terrible person, and the fact that I filed almost the identical request 2 weeks ago, Rebecca Krill. I waited a month for a response. I got nothing. So to say that they're changing, this is no isolated incident here. I wish I had written the complaint better. I wish I had put the face sheet on, because there are more violations contained in this.
Thank you. Okay. Anything else for the good of the cause? Okay. Public comment on the motion? Seeing none, please call the roll.
On that motion, Member Fisher.
Can you read the motion again?
The motion is to find a violation of Section 67.25 for failing to respond in a timely manner.
I'll go with that. Okay.
Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon. Aye. Eldon, aye. Josh Wolf, absent. Member Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. The motion passes.
Please call the next item.
Next on the agenda, item number 9, file number 17045, complaint filed by Anthropo against Kate Patterson and Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner. This was heard by the Complaint Committee on August 22nd, 2017.
So this request was received via fax message. It was received by the Arts Commission at around 4 o'clock. It was late in the day, but it was still during business hours. They should have received, Ms. Tribou should have received her response by the end of the next business day. She didn't receive it until the day after that. I believe the Arts Commission didn't see the fax until the morning of the day after they had actually received it, but that isn't an excuse. So we thought there was a violation here for the failure to respond in a timely manner. As to the issue of responding in a complete manner under 67.25, at the time of the receipt of the request, they did not have any responsive documents, and that was communicated in that response from the Arts Commission. And so, but at the time of the request, they didn't have any responsive documents. And so, anyway, I won't give any conclusions, but that's our report.
It's hard for you, isn't it?
Yeah, it is.
Okay.
I know.
Ms.
And
Giroux, 5 minutes.
And to continue that, Member Wolf pointed out that documents should be sent on a rolling basis. And Kay Patterson stood up here and said, "What? Really? Oh, I didn't know about that." And I said, maybe somebody should read the ordinance, since I have sent many emails repeating that over and over again. So there's the fact that these, rather than send another IDR request and jam up, create a backlog for you people, this woman needs to read the ordinance. It was the same thing with, you had to educate her about an IDR. What? It didn't have to be within 24 hours? Somebody needs to read the ordinance here. And this gets, and then, of course, here's my narrative, which is the same thing over and over again. She claims that I send duplicate emails. Well, she should have sent it on a rolling basis. I eventually did get the documents, but they didn't come from the Arts Commission. They came from another source. This is a violation, again, of 6725, and she needs to be educated.
Any persons or witnesses provide any facts or evidence on behalf of the petitioner? Seeing none, Ms. Patterson.
I think that I summarized it pretty accurately. I mean, we received the facts the following day after it had been received late in the day previous to when we discovered it. I will also concede that while we did not have the records, and I communicated that I should have been more, I guess I should have let her know that we would be in touch with her when we did have those documents. But I'm happy to say that we were in touch with her when we had the documents. And here's the email, which I sent to Victor with a cover letter on September 19th with an update, because you had asked me to just verify if we had sent that record. And here's the email. And it is from a member of the Arts Commission, Ann Trickey, and she has included Ms. Tribou here. And it is the respondent brief to appeal 17026, and then it includes all the attachments that came along with it. So there you go. So we did respond. And she did not send an email reminding us. We were proactive and we responded when we had the document.
Thank you. Any persons or witnesses on behalf of the respondent by writing any additional facts or evidence? Seeing none, members?
I'd like to make a motion.
We need to do rebuttals first before we do that. So any questions or clarifications for any of the parties? Seeing none, Ms. Patterson, 3 minutes for rebuttal. If you have anything to add. No? Ms. Tribou?
Page 210 of your packet is the other side of my narrative. Kay Patterson invents citations. She doesn't bother to verify the codes and stuff. And in her initial response, we don't have to supply you with the records that we feel jeopardize the safety of our staff and commissioners. And she cites the California Evidence Code 1041. 1041 is only used in criminal matters. There are 4 elements that a person has to meet, and I quoted them last time. The Crime Stoppers, this would be in testifying in open criminal court, which does not apply. She hides behind it very often. The 4 elements are an act of Congress, the public interest, confidentiality, in the interest of justice in a criminal proceeding. An enforcement officer? I don't think so. Representative of law enforcement? Kay Patterson is not that. A volunteer or employee of a Crime Stopper organization. She spouts out these codes that she doesn't bother to look at, which makes these hearings unbelievably time-consuming. And then the multiple emails she sent. In the thing that she put down, she sent that thing to 2 different emails. So imagine what it's like tracking this stuff. It's near impossible.
Okay. Anything further? Is there a motion?
I'd like to make a motion to find a violation of Section 67.25.
Moved by member testified.
That was said so fast. Could you repeat that?
6725. Untimeliness. Moved by member Tesfaye, second by member Eldon.
Can we ask questions, though? No, you. You're saying timeliness, but I thought I heard that. Oh, they conceded they were late? Okay. I thought it came on a weekend and we saw it the next day.
It wasn't a weekend. It was at 4 o'clock on a weekday, and they didn't see it till. That's what I saw. It said 1604.
Can't see. Ms. Patterson, did you concede that?
Yeah, it was received late in the day, and we didn't see it till the next day.
So you conceded that you were late?
Yes, I did.
All right, I'll go with that.
Okay, public comment. Seeing no public comment, call roll.
On that motion, member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Call the next item.
Member Kanata, you can always just pass, and that way you're always last.
Can I ask a point of order
Next on
question?
the agenda
Chair?
item.
Hold on.
Point of order to Chair. So what happens with this now? I used to have to do something with the violations.
Only there was no recommendation to move it to committee. If I do feel like it needs to, I'll refer it.
Okay.
Next.
But if you're compelled,
Not at all.
okay.
Next on the agenda, file number 17067, complaint filed by Ann Trapeau against Ann Trickey and the Arts Commission for allegedly violating Administrative Code Section 67.7 by failing to post an agenda for a policy body program director hearing, June 14, 2017. This was heard by the complaint committee on August 22nd.
So this was regarding a meeting that the petitioner said there was no notice placed on their website. An email went out to artists that this meeting was occurring. That's different from a meeting being posted. That's all. Those are the facts that that I know happened, and I'm sure they can expound on it.
We found jurisdiction.
We did find jurisdiction. Yes.
Great. Okay, Mr. Trapeau, 5 minutes.
Okay, I'd like to correct the heading. The spelling of Ann Tricky is A-N-N-E. I know this because I get snotty emails from Kay Patterson. Absolutely unsolicited, but nonetheless. Okay, so this is a violation of 67.3D because I was prevented from entering this meeting. I actually went to the door, knocked on it, and it was opened a crack, and I was told that I could not attend. Barriers to attendance prohibited. So 67.35D violations. My name is Trudeau, not Dadish. The city attorney memo states that. I wanted to attend, and when I found out about it, I went out and I looked on a board, which is to the right of this meeting room, and there was nothing posted. So I did find out about it, and I wanted to go and listen in because I knew this individual, and there were a lot of adverse dealings. He had done some things to me, and I just wanted to listen in and see what was going on here. I was told that I could not attend. So in Kay Patterson's response, which is a typical nonsensical response, she doesn't really cite anything that you could hold your teeth on. She says, established and codified in 1996. What's she talking about, the Sunshine Ordinance? Because she didn't reference anything. Is she talking about a city attorney memo that says that this is an administrative meeting? Is she talking about Proposition L? I don't know, because she hasn't provided me enough information. So this, you can see from the documents, was held as a public meeting. I've listened to them before. Also the person, the witness or the complainant in this case didn't appear. So, and she did speak the words that were contained in the thing. Her name was Harrigan, I believe. Why is that document even in there? So I'm having some real trouble with this because it was only noticed to artists, well, maybe members of the public, maybe former street artists had issues. It's a public meeting. Anybody can attend. So my issue is that I was prevented from attending. I went there, and I was prevented from attending the meeting. 2 people were not present at the meetings, and their written comments were included, page 249. So, and Kay Patterson forgot to send the PDF attachments, page 248. I don't see them in the file, and I didn't get it, and she's not here with the documents she sent. All we got on 251 are attachments that were later sent on June 16th with me included. That's it. It's a violation. I was prevented from attending that public meeting.
Are there any persons or witnesses provide any facts or evidence on behalf of the petitioner? Seeing none, Ms. Patterson, 5 minutes.
So first of all, I mean, I don't know for a fact whether or not she was refused entry to this meeting, so I haven't seen any evidence that there was an interaction where she tried to come and was refused. So I can't speak to that, but I can speak to the fact that this is not a policy body. It is an administrative process to help resolve conflicts within the program, and we do, as a courtesy, send notice to all active members in the program. Mr. Boo does not currently have a street artist license, so she would not be included in any outreach relative to a meeting of this nature, where we let them know that we're going to be, basically hearing a topic, and it's presided over by the director of the street artist program. There is no member of the commission. There is just the director of the street artist program, and So I'm happy to answer any questions related to just the fact that it was not a policy body and we don't have to publicly notice it. And like I said, I believe we did provide her with the records that she did request. And I have her email from Friday, June 16th. She says the meeting was not agendized and members of the public were not noticed or given opportunity to attend. The attached email was sent to artists. Additionally, there were 2 people who were not present at the meeting. The written comments were included at the hearing. And so, I mean, she's not asking about attending, and she is just asking why it was not agendized, and we provided her with a response. And I'm very tired, so it's all.
Thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, members?
Yeah, I'd like to go first. Ms. Patterson? Sorry, I can't see you behind this. So, I mean, thanks for that explanation. You mentioned that the notice of this meeting is sent out to all the people that pay I believe it's $884 or whatever.
Yeah,
it is
who have
per
licenses.
year.
Mm-hmm.
So it's sent out to everybody
in the program.
Mm-hmm. And they can willingly walk in the door and attend. It's not like it's a closed meeting of the. And I don't pay $884, but if I knew about this meeting, is it that public that I could come into?
I can't imagine any instance where we would refuse a member of the public who wanted to just come to the meeting.
It's likely. Okay,
yes, it's likely.
Member Tesfaye.
So you were saying that it's sent to everyone on this list, but why isn't it also posted on your website, daily calendar, publicly noticed?
Well, because we don't, it's not a policy body. We don't have to. We have other public meetings. So this is just, it's a meeting to resolve an issue within the program, and we're not required to do so.
And which members of the Arts Commission are present at?
No members of the Arts Commission are present. It's just presided over by the director of the program.
Okay. Can we hear what Mr. Boo has to say about that very briefly?
I have attended previous meetings of this nature, and I've seen 3 to 4 staff members there. The purpose of it...
No, but members of the Arts Commission...
Commissioners
are there?
Commissioners are not there.
Okay, that's what my question was.
And what is usually decided at the end is that the person is brought in and told that his permit will not be renewed unless he signs a statement saying he wouldn't offend again.
Thank you.
Member Moss.
Hi, Ms. Patterson? I had a few more questions for you. So, why do the agendas for these meetings include the Sunshine Ordinance Know Your Rights language?
Let me see.
It's at the bottom of the page.
Oh, I see. I don't know.
Okay, but all right, I guess that answers that question.
Yeah, I don't know.
Do these occur in rooms where there is audio or video recording available?
Not video, but yes, we have the capacity to have audio recordings.
And do you record audio?
For these meetings, I'm not sure, to be honest.
The answer is yes.
Okay, so there is audio for those.
Oh, well, I don't know. I would have to verify that.
Oh, so potentially the answer is yes. Okay. Can you just explain a little bit about what this is actually? Like what happens during these meetings? Like what is the purpose of these meetings?
So like I said just a minute ago, the purpose of these meetings are to resolve issues that occur within the street artist program. So, a street artist sexually harassing another street artist or things of that nature.
So, and these are considered public meetings?
They're not public. They're for members of the program. But like I said, we wouldn't deny someone for coming.
Right. No, the reason I ask is that some of these letters, so for example, if I'm looking at the document starts on page 257 of the packet, which is a notice of intent to recommend denial of certificate or renewal. And then when I scroll down to the bottom of page 258, it says prior to the scheduling of a hearing with the committee, however, you may wish to meet with the program director, parentheses, in a public hearing. That is the public hearing that it's referring to there?
Okay, you're looking under passive meetings. I'm sorry.
No, page 258.
Page 258. Well, this is what let me just grab the packet.
Okay.
I think that the respondent should have.
All right, Ms. Trudeau, extraneous conversation is not necessary. It really disrupts the meeting.
I'm sorry, I need the
Thank you.
packet because what I brought was from the last hearing. Thank you, Victor. Okay.
Okay, so you're looking at page 258?
Okay, so yes, I have
And it
that.
says,
It's-
second to last paragraph, prior to the scheduling of a hearing with the committee, however, you may wish to meet with the program director, parentheses, in a public hearing. The program director hearing is that public hearing that it's referring there?
Well, the committee would be referring to the Street Artist Committee.
Right, but then it says the in parentheses in a public hearing, where it says you may wish to meet with the program director in a public hearing.
I'd have to just verify that. I'm
Okay.
sorry.
Okay, that's all my questions.
Anybody else? All right, so based upon this, because the notice comes from which committee?
It does not come from a committee, it comes from staff.
Okay, so if we go back to the same paragraph that Member Moss was pointing to, it
Right.
says, prior to the scheduling of a hearing with the committee, what does that mean?
You know, can I request that we continue this, just because, this is not, this is not a program.
Let me
Yeah.
ask you a question.
Sure.
Who in the San Francisco Arts Commission or Department would know about
Yeah,
this?
well, I'll make sure Ann Trickey is here, who's
Okay.
now the acting director of the program.
Okay.
I feel like I just don't have the specific answers to your questions, and
Okay.
it seemed more straightforward when I was preparing for this. So
Got it.
I'd love for.
You understand where we're going with
Yeah,
this?
absolutely. I totally get it, and I see where you're going with it, and I just feel like I would rather
I
just
hear you.
continue it. Thank you.
No problem.
I'll make a motion.
All right, wait a minute. Let's just finish the process, and then we can do that,
We
all
have
right?
to do rebuttals. Yeah.
Okay, so any other questions? Should we move to rebuttals? Ms. Patterson, do you have any rebuttal?
No, I just apologize for not being more prepared. I feel like I wish this had come out at the last hearing because I would have ensured that someone else was here to support me in this. So I just apologize for that.
Yeah,
So-
I would just say that I don't think any of us comity members picked up on that
Yeah,
until
so-
Member Moss brought it up.
Yeah,
brought it
okay,
up,
thank
so-
you.
Sorry.
That's all right. Mr. Trudeau, rebuttal.
Once again, the respondent has an obligation to come prepared, to come with documents, and not to leave fishing. I have traveled on a plane 3,000 miles to come to this hearing. I really wouldn't like it continued. She has not really answered your questions. She's sort of waffled back and forth. In this paragraph, page 258, you have evidence. Prior to the scheduling of a hearing with a committee, that would be the Street Artist Committee, for a formal hearing to withhold reissuance of a permit, and you have the documents for that, you may wish to meet with the program director, which is this administrative hearing that we're talking about, in a public hearing to discuss the report and to request consideration of renewal of your certificate. If you're willing to sign a statement attesting to the understanding of the street artist permit and promising to comply with the law, the program director will sign as a witness to such assurance. That was the purpose of this meeting. Okay, Patterson never attends. There is usually an audio. It's very small. The recording is always very bad, but I have attended these hearings. I know what they're about. She doesn't. She has no clue. She has not come prepared. And for you to continue this over means I have to make another cross-country hearing because she's not prepared and she doesn't know what she's talking about. That's pretty bad. So here, the last sentence, the following is our dates and times for a meeting with the program director. That's what we're talking about. Page 259 are 3 dates, and that's what this Jeff Potter elected to do. She was not there. She doesn't know whether I was denied entrance or not. She didn't supply any evidence, she didn't come prepared, and she wants to postpone. At whose expense? We have just sat here. I've sat here from 4 o'clock onwards. And plus, you have the notation of Know Your Rights Under the Sunshine Ordinance for this meeting. Page 246. What could be more clear? This was a public meeting. They've said so. I was denied entrance. And at previous meetings, I did manage to get in under the threat of them calling the police, when instead Bill Graham, the director of security, came out and basically screamed at Ann Trickey.
Okay.
I'll make a motion to continue this item to the call of the chair.
Is there a second?
Second.
Moved by Member Hinsey, second by Vice Chair Hyland. Any public comment on continuance?
Can you say to the call of the chair, it goes away, it disappears?
No, that's tabling. Is there any public comment on the continuance?
Yes, it's random. I happen to be here tonight.
Can you pull the microphone?
About 5 years ago, I wrote a kind of an extended profile of a street artist, and I had to follow him around for a week. And as he was tagging, you'd make these faces get really angry. I think it would be really useful if the secretary of this task force invited the members of the street artist program to the continued hearing to see what they thought about this and get their opinions. Thank you.
Thank you. Any other public comment? Seeing none, any other comments? Yes, from members. Member Canada.
I don't think I can vote for a continuance, and if we do have a continuance, I think there should be a violation for not sending a knowledgeable person here. I mean, the representative of the Arts Commission stood here and said she has no idea what this stuff means.
I would just counter on that I didn't learn that this could be heard by a committee until Member Moss brought it up. So I think that's why I'd be open for a continuance. If I had that knowledge ahead of time, and if even at the committee level where we heard this, I'd agree with you that somebody didn't show up to explain what that is. But at the time, it just sounded like an administrative process. So until it was, that language is buried in the language. So
yeah, but it's a language that the representative here of the Arts Commission should be aware of, I think.
Well, maybe. Anybody else? Should we vote?
On that motion,
Can you repeat it?
the motion is continue the matter to the call of the chair.
Sure.
Vice Chair Hyland.
Pass.
Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
No.
Kanata, no. Member Fisher.
All right, aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Let's call next item.
Next on the agenda, item 11, Sunshine Ordinance Task Force Annual Report.
Not ready yet for that. Sorry. I will definitely be ready next month.
Sorry.
This
problem.
month has been a little
problem.
Okay. So
Take your time.
okay. So we can continue this item to. Okay. Great. Thank you. We'll just continue it. I don't think we need to take a vote on it. All right.
Matters continue without objection. And there's no public comment on it.
No.
As far as I know.
Right.
Item 12, report from Sunshine Ordinance Task Force committees.
Okay. Anything to report? Complaint committee. Anything? Okay. Notable. Complaints and amendments.
At our last meeting, we just had some issues over client lawyer
Privilege.
privilege.
Is there anything that you feel the task force should it be clarified? Anything that the committee needs clarification on? Because you're hearing complaints, which two other committees hear complaints on too. So,
refresh my memory.
We continue that matter to the call of the chair to allow the parties to work together. The petitioner wanted additional time to look into the requirements of attorney-client privilege.
Okay.
And
would it be helpful, DCA Cola? Do you have a simple guide that you can provide us that's like available to like from the Bar Association or something?
Well,
or is it too?
I mean, if somebody asserts attorney-client privilege in a court proceeding, if the other side challenges it, you've got or not. Well, the judge could order an in-camera review, which I don't think you would have the authority to do.
No.
But you could mandate that, or you could request that they provide a privilege log, where they describe what type of document it is and how the attorney-client privilege applies, which I think for the most part we sort of flush that out in our hearings anytime somebody does assert an attorney-client privilege. I just will say earlier, I know you did make a statement about how an attorney for the city cannot provide advice to a department as far as withholding records under the PRA or Sunshine, and that's not actually the case. An advice attorney for a client department can, and they have an obligation to advise them in certain cases not to disclose, or if there's exemptions that apply for particular records. Despite what the Sunshine Ordinance says, the California Constitution actually takes precedent in that case, and the attorney-client privilege and attorney-client relationships are laid out in that.
So, all right, just to respond to you, in 6721I, it says the San Francisco City Attorney's Office shall act and protect and secure the rights of the people of San Francisco to access public information at public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public records for the purposes of denying access to the public. That's what I'm referring to.
Yeah, the California Constitution overrides that.
How's it that this made it to the ballot? Then
how is it that it made it to the ballot?
Yeah, why? How could if there was a conflict with the state constitution? How?
I mean, there's plenty of laws out there that conflict with each other. You just go up the totem pole.
Okay.
Yeah.
All right, I hear you. Okay, so you're saying that statement is that the California Constitution. Because the one thing that this body's held in the years that I've been on it is that if the city attorney wants to provide advice, has to provide advice to everyone in the form of like the Good Government Guide or something like that, but to formally advise a particular custodian who has a record on how to prevent the access of the information was not legal. As per this particular section, that's what this section is meant to.
Well, sure, and I think there's a reading of that section that doesn't necessarily contradict the California Constitution or attorney-client privilege. Attorney-client privilege is an exemption to disclosure, and in a way, it makes it a non-public record. So, a reading of 6721I could say that no one can advise a person or a department to not disclose records that are a matter of public record, except for those that are exempt from disclosure. So, I mean, in a way, that's a fair reading.
Right. So that's the question is, for this particular point, I'm not suggesting that attorney-client privilege is applicable.
Okay.
I'm saying just in general, if the city attorney if somebody were to ask, I mean, there's a lot, even something that happened tonight, I didn't bring it up, but there was some inference in advice that was given by the city attorney to a respondent in one of tonight's cases was on how not to, this is basically how not to, or how to withhold this information. And it's really incumbent upon the respondent by themselves to do that.
Well, why do they have advice counsel then?
Yeah, that doesn't. Under the state CPRA, that is absolutely not the case. I'm just trying to give this information. If an agency is concerned that something might be unable to be produced because of an exception to the CPRA, then
I get you, but that's not what I'm saying. It's for the matter of actually actively denying access.
oh, like I have this document and I don't want to give it.
Exactly. How can I not do that? So that's where I was going with when I made that statement.
Yeah. Their advice counsel would tell them whether or not they reasonably believe that a valid exception or exemption applies, and if it doesn't, they wouldn't instruct them to withhold it on some fraudulent basis. They would be violating their ethical rules by doing so.
Right. No, exactly. And so that's why I was just stating that for the record, not specific to that particular case. I was just stating that there are rules in here for that, just so that everybody knows what it is. But I agree that there's a fine line to this. But any exemption, like client attorney privilege, obviously this provision would not apply to at all. Just like any of the other exemptions that are listed.
Sure.
Okay. That's all I want to mention. Okay, good. So getting back to attorney-client privilege, is there some kind of simple guideline that you might be able to provide us that maybe, I don't know, that you guys use, that the city attorney's office uses, that so that we have some idea? Because otherwise it becomes a question at every single hearing.
I don't think that there's no real spreadsheet or chart that someone could create that would apply to every single circumstance.
Okay.
If someone asserts attorney-client privilege, you say, well, on what basis do you make that?
Okay.
If there's pending litigation and it's regarding a confidential communication between an attorney and a client.
So then maybe it would be good in your memos if you can put those questions in there when attorney-client privilege is asserted. Did you do that in this one?
I think I did.
You think you did? I don't recall reading. I'm not saying that it wasn't there. I may have missed it.
Sure.
But that would be helpful for folks. So if it's there and you're already doing it, thank you very much. Appreciate that. Okay. Anything else from compliance amendments? EOT, anything? You didn't? Okay. Anything that is coming up for you other than outside of complaints? No?
No, only complaints coming forward.
Only complaints right now. Okay. Rules Committee.
Okay.
Anything to report?
That's me. So we did actually have a meeting. We made a couple suggestions to the bylaws, which I think will be before you next month. The one thing Victor did possibly want to cover tonight is just a brief administrative thing about inserting a statement about making ADA accommodation request in the meeting notice. Victor, do you want to?
Currently in our complaint procedures, we acknowledge that there may be special circumstances where they may not be able to attend and we can provide accommodations. We just wanted to bring it to the members of the public's attention with my notice of hearing that accommodation is possible so that they don't have to read our procedures to know about it. So I agreed that with my notice of hearings, I would insert some type of language stating if there's a problem with you showing up, please contact me and we'll see if we can try to accommodate you.
Okay, great.
And there could be there's standard ADA language for reasonable accommodations.
Just a point of order. You didn't put chair's report in the agenda?
I did. Yes, item 14 is
item 14. Okay, great. All right. Sorry, I skipped that. I'm having a migraine tonight. One thing I wanted to maybe, I'd like the Rules Committee to consider at its next time is I think it's important that we keep the discussion and the testimonies from folks to be very specific and focused without a lot of additional rhetoric. I appreciate public comment and with everybody, has freedom to say what they want, but for the purposes of hearing complaints, I think sometimes outside comments are not helpful. It doesn't make a difference because we're charged with trying to look at the specifics and the rule of law here in a lot of ways. So I'm wondering if you could maybe think about and discuss maybe something to include in the complaint procedure and maybe an opening statement that the chair, myself, or in the future, the chair and the chairs of the committees would announce at the very beginning of the meetings. So for your edification, I just was mentioning that I want the Rules Committee to look at an opening statement for all the chairs to kind of remind or note to the people testifying, not necessarily public comment, but the people testifying that are parties to a case, to keep their comments pertinent and focused on the case itself, and that any additional rhetoric that is not part of it is not helpful. And it's just a statement. They can continue to say what they want, but I think it's important to reiterate that over again. I don't want to necessarily abridge people's public or statements or testimony, but I think it's important for us to say, at some point we're seeing it and we want it. We would like people to self-facilitate. Okay, I don't have anything else for anybody else for the Rules Committee? No? Okay. And IT has not met. Is there anything to bring up? Nothing to, okay, great. All right, next item.
Item 13, I believe this is a new regular item for us. It is a hearing to review legislation and policy at the federal, state, and local levels, as well as other jurisdictions related to the Sunshine Ordinance and California Public Records Act. I provided a handout to you provided by Member Moss today related to some pending legislation that is might be something you would like to review.
I put this on the agenda as a new agenda item because there were a lot of new laws that were either amendments, tweaks, or brand new laws that may or have some effect on us, and just the ordinance itself. There was some, if there's work done on the CPRA or the Brown Act, those things also have an effect on us too. So I think it's a good idea as we move forward. Now that there's probably 1,000 new placeholders for bills in Sacramento, they imposed more work for themselves. I think it's important that we keep track and updated on this stuff. And if it comes to pass that we might want to take a position, and we might want to, have the city take a position on these things, or have a discussion about it, for whatever reason, I felt it was a good idea to have this in its own separate item where we can have focused discussion on it. And there's a lot of stuff that's like just recently coming out too, this whole thing with the license plate data stuff is, that is very interesting. Okay, is there anything anybody wants to bring up on that in that area? Member Moss?
I mean, I could just tell you, I mean, this handout kind of says it all. We'll know more about what becomes the law, on October 15th when the governor's deadline to sign things passes. Of the things on here, though, just so you know, if I could just go through what their relevance is real quickly, because I just tried to grab some uniform information. AB 1479 is kind of a weak reform. If he signs it, all it's going to mean to us is that there is now every agency is supposed to have a central custodian of records. SB 345 is probably not going to be hugely part of our jurisdiction because it's placed in a different part of the law. I don't think it's part of the Public Records Act. But what it says is that police departments have to post all their police and training materials that would otherwise be available on the Public Records Act online. And so people may be looking to us to say, hey, why is this thing not online? Can you determine whether it's a public record or not? The 492 on the next page is not really of much relevance to us in terms of, I don't think it's going to impact us at all, but basically it's just if a person obtains a public record from, say, the city of San Francisco and then tries to sell it to somebody else, under a lot of circumstances, they're going to have to include all sorts of information up top, which won't be a matter for us to enforce. The big one for us to look at is AB 1455, which is on the governor's desk, which is going to exempt a whole new category of records from disclosure. And those are records related to collective bargaining. The language is is a little complicated, so we may have to start digging into that a bit more. And then the other one on here, AB 459, which was already signed by the governor, is about video and audio recordings. Largely, this is brought up about body cams and the concern that body cameras might reveal, say, rape victims, incest victims, women who've been beaten, men who've been beaten, that whole sort of thing. And so that is now exempt from disclosure. However, there seems to be some wiggle room that if the facts of a particular case, the public interest is best served by disclosing, then it can be disclosed. But
and also the victim or the victim's family.
Right, and the victim's family, and sorry, that's another thing. The victim or the victim's family must be given access to the recording. So those are the sort of basic things that are out there. There wasn't necessarily much. I didn't see much passed related to the Brown Act. I think there was one that just fixed errors in the language and changed when to if and that to the, and I didn't include that in here because I didn't think it was worth wasting people's time with it.
Thank you. And I obviously also invite DC Acola when he, court cases, anything relevant, with regards to policy or legislation.
Oh, did you want me to talk about the license plate reader?
You can. Let me just finish my point. This is you can feel free to add things to the agenda. Just let Victor know. Go ahead.
So this is a case where my employers were a plaintiff in a California Public Records Act suit, and so there's only a limited amount that I can actually talk about at this point with this litigation. But essentially, this was a case where the Electronic Frontier Foundation had asked for a bunch of records related to automated license plate readers, including a week's worth of data collected by the automated license plate readers. And for those who are not familiar with this technology, these are high-speed cameras that are attached to stoplights or to police vehicles that collect the license plates of every car that passes by, both as images and also turning it into metadata. And then that stuff is uploaded to a database, which then allows the government agency to, they can set an alert for you so they can track you in real time if they are looking for you, or they can put your plate in and look historically, see all the places that you've been. They can put in an address of a location and see all the the vehicles that have visited that location, all sorts of fun analytical stuff that will creep you out. But the question that had come up was whether this data that's collected on a massive scale on everybody, regardless of whether you're suspected of being involved in a crime, was disclosable under the Public Records Act. the law enforcement agencies, which was the LA County Sheriff's Department and the LA Police Department, had said that disclosure of that data was all exempt under the investigative privilege. So essentially, everyone in Los Angeles is under investigation. Therefore, we don't have to release any of these records. The California Supreme Court was not convinced by that argument and ruled in EFF's favor, and it sent it back down to the Superior Court to have things ironed out. And that's the extent of what I can tell you about it. But the overall question that that departments are going to be facing around the state is, if a request comes in for raw license plate data, do you have to provide it? And what privacy concerns are you going to take into account? Because as you can imagine, that data can reveal a lot about somebody. So you could place a address of, say, a reproductive rights clinic in there and get the license plates of everybody who visited or who was seen visiting that or passing by that area. Things that could reveal personal things about you. So that's a tricky issue that agencies, courts, people in general are going to have to struggle with.
Great.
That's it.
Thank you. All right.
I can't track
anything else for this item. Call the next item, please.
I just wanted to state that we still have one member of the public in the room. And we should ask if he has any public comment for the last few items.
Do you have any?
Yeah, this is why I came here tonight.
Oh, okay.
Oh, come on in. Come on up.
Okay, so I brought, and I'm asking the Secretary to place into the file on this item an excellent article by Dan Walters, who I guess would be the doyen of Sacramento journalism. And it talks about the specific concerns and the specific actions of the legislature in revising the CPRA this year and the summary of certain bills, especially AB 1455. But I also want to call out Senate Bill 92, which prohibits the release of emergency action plans in the case of dam failure. And if you know California history, you know that that is the largest loss of civilian life from a human-made human disaster in the state of California.
Oh, so, he
Sorry?
provided.
I provided it for the file for your record. But also returning to AB 1455, it was, as Member Moss mentioned, the big one in the room, and it affects some of my work, and it is on the governor's desk, which means if I've got the Parley Pro correct, you can take a unanimous vote to take an action because it is an action of urgency and it actually impacts the Sunshine Ordinance, and therefore it is within your jurisdiction. And therefore, I have taken the liberty of proposing a draft, I guess we should say, initiative for you. And I urge your consideration to take action tonight to ask the governor to publicly ask the governor to veto AB 1455. And here's a copy of it if you wish to review it. Thank you.
Can you say your name for the record?
My name is Thomas Bussey.
Yeah.
I'm freelance.
Massey was your last name?
Bussey, yeah.
Bussey.
Yeah. I don't write under that, but yeah.
So I have a question for DCA Cola. Can this task force take an independent position on legislation publicly?
Like the task force issue a letter coming out in one way or the other on something?
Right.
I want to say I believe you're free to do so, but I'll have to look into that. I'll get you an answer before next meeting.
Okay, because I believe that no commission can take a position on legislation. It would have to be considered an official act of the city because they would be representing the city. And so I'm just wondering, based upon what is our status kind of thing, are we free to do that or not?
Yeah, I'll have to.
Okay.
I'll have to do a little legal research and find out.
Member Testa?
There's probably a difference, but I know that state agencies can take positions and vote on them for legislation.
Right. Are you saying that we're state agency?
I'm not saying we're a state agency, but a state agency, when they do that, is not speaking on behalf of the state. So I'm not sure if us taking a position on something would mean speaking on behalf of the whole city automatically.
I just don't know if there's some local law that prohibits it because we're an incorporated city. So it could apply to us and maybe not to some other city or county. So, so the only thing I could say to this is with the request from the public commenter is if we wanted to take action on this as an emergency item, that there be a caveat until we get some definitive, legal advice as to whether we can or cannot. And that would, if we wanted to take action on it, it would be conditional on that answer. Member Moss, what do you think about that?
Which measure are we talking about?
1455. The request from the public was that we could act because it's kind of an emergency item. It would happen before our next meeting. That this would have such significant effect that we should take a position on it to oppose it.
So for my honest opinion is like twofold. One is that I think that we have 11 days for his deadline, and that by the time we got something drafted and people agreed to it and we got it reviewed by DCA Colo, he probably will have signed the bill or vetoed it. So I'm not sure that it's worth putting that much effort into it. Also, it's hard for me to think about this as an emergency measure because this bill has existed for months and months and months, and I don't think that it landing on the governor's desk is a particular. I mean, it was presented to the governor about a month ago, so I mean, there's no reason that we, it's not like we discovered this yesterday that it just sent to the governor. I mean, it's been public that it's been to the governor's office since the day it got sent there.
Okay.
So.
All right. Is anybody else have any discussion around that? Okay. Sorry. Okay. Next item.
Item 14, Sunshine Ordinance Task Force Chair's Report.
Okay. So we are approaching a little bit of a backlog, and I think we're going to need to have a special meeting before the end of the year, just one. So we can keep up and be on track. Is there any special way you wanted to just go about that? I mean, everybody's going to have to schedule it. Should we send out a doodle poll or something
I
like
can
that?
send out a poll.
Okay.
The most likely date will be a second Monday of the month.
Okay.
I don't believe there's a big rush to schedule it at this time with the holidays coming up really quickly.
So this is just on notice?
Yes.
Okay.
We're starting to build up with the two committees feeding into the full task force. We're starting to build up a little of a log.
Okay. So just to flag it that we may or may not have to have an extra meeting this year. Okay.
Right.
I have some other items, but they're not listed here, so I'm going to do it in number 16.
So I'm just had a question about in order to deal with the backlog. So this is we need to get more things before the full task force. And so would this be something in addition, or is this something where we could dispense with some of the standing committees for a day and have full task force in place of a standing committee?
That's a possibility.
I
You
just
could do
wonder if
that
would
too.
solve it. It's because that way, if you had something instead of complaints committee or instead of we could just skip.
But
a
that
whole
means,
step.
but granted, it can't just be 6 people showing up, because then people are going to continue it.
Yeah, that's
so it'll be called as a special meeting. People need to show up.
Yeah, I was just curious whether that was an option.
Okay.
So,
but it's a good suggestion, because we already have
I won't
those
exclude
rooms.
the other meeting dates.
Okay.
When considering a potential special.
Member Kanata.
Since Member Moss brought up 6 people at a meeting, if you can quickly do it, explain why we can't change our voting process.
Okay, so this goes back to 2010, 11. Actually, it goes back to 2009. We were having some at that time I was on the task force. We were having some serious problems with attendance. The task force, over a course of actually 3 solid months and maybe a year of research, had determined that it was not a charter type of body, and that it didn't need to comply with the charter codes regarding bodies that were under the executive branch. And bodies that were created by the Board of Supervisors, because it was created by the voters, that we were free at the time to be able to change our voting threshold. Now, when you look at what the voting threshold is, that was the big question. It was to many people it was a little ambiguous, because it says that the votes must be made by a majority of all the, let's say, supervisors. Okay, so the Board of Supervisors, if they had quorum, okay, which would be 6. But one person kept voting no, okay, that would be the case. They couldn't then say, it couldn't be like standard Robert's rules where if you get quorum, it's just the majority of the quorum, okay. Well, that didn't fly very well with a lot of folks. And so it wasn't addressed directly. It wasn't ever addressed directly at all. A different issue came up that forced the removal, or I would say not removal, I would just say the non-reappointments of almost the entire task force. In fact, it was the entire task force, pretty much, I think, except, it was making...
They kept Richard Nee. And
they kept David Pilpel. Didn't they keep David?
Yeah.
No, she can't.
It was Allison and Richard.
it was Allison and
they were. So here's the deal with that.
Pilpel was new. He came on with. He was recycled.
Recycled. Okay. So as you know, our makeup is, and real quick. So our makeup is.
And Susanna Monet. Sorry. So there were 3 total.
Right. So we have 5 members that are nominated by external organizations. The rest are directly appointed by the Board of Supervisors. On the nominated appointments from those organizations, the Board of Supervisors can only give a thumbs up or a thumbs down. Okay, they must accept whatever nominations come from those organizations. They can't, there's no special application for them. So a list comes from the Society of Professional Journalists for 2 members, one from New America Media and one from the League of Women Voters. And so it's 4 members. And so they can only give a thumbs up or a thumbs down to accept that nomination or not. They can say, well, you don't accept the nomination, go back to your organization and find us another name. So in 2014, there was some reappointments happening. The Board of Supervisors chose not to approve any of the nominations set forward in 2012. And so the current members that were on there since before 2012 were holdovers, and the city allows that. So in 2014, David Campos, who was then supervisor, had asked DCA John Givner, so how does this work? Does it apply to the city rules, which is 60 days? So the Board of Supervisors is 60 days to install somebody or reappoint the person that's already there. And his answer, without flinching, basically said, well, Sunshine Task Force was voted in by the voters. It's not executive branch. It is not legislative branch. It answers to state law. State law has no limitation. So the holdover could stay in there forever, pretty much, and not ever be appointed or reappointed in that kind of way. That seemed to confirm to a lot of people in the Sunshine world that the Sunshine Ordinance Task Force is very, very much independent or separate from the three branches of government. That it was because its oversight was basically focusing on state law and some of the local law that was approved by the voters. So that's kind of where that stands, and that question is still out there.
Bruce.
Yes.
Why was there in a nutshell, such objection by the Board of Supervisors to going down this road?
Some of the consternation around this was around a decision that was made by the Board of Supervisors around the Park Merced project. There was, during a hearing of the Land Use Committee, some amendments were introduced improperly, according to the task force at the time.
Got it. So this was just unfortunately happened to come up at that time that that had all taken place. I got
Right.
it.
I mean, the task force had discussed in public meeting that, yeah, this could backfire, and we'll find out that the next time that we, it could come up. But we had gone on for months and months and months and months. Nobody said anything, and everybody knew it.
Lying in wait.
Well, in a way, I guess. I'm not going to add any rhetoric to this. But I'm just wanting you guys. I know. Thank you.
That's what I'm here for.
I hear you. But that's kind of kind of how it went. So,
just to add a footnote to that, one of the things that also delayed us is the appointment of a
disability seat. Yeah,
that pretty much
the backlog part. Yeah,
we actually. When I was first elected, we met for 2 meetings, and then we shut down for 6 months.
Right, 6 months. And then
we came back.
I had applied.
For the backlog. That's how we started.
I had applied for reappointment like 3 times, and they denied me every single time. And I was just like, look, I'll follow whatever concerns you have. I won't make a fuss. Just let the task force meet, so it doesn't create a backlog, and they refused.
I think finally Bruce Oka came on.
Yeah, finally
Bruce Oka came on for 2 years, I think, and then Fiona came in after.
Well, it's like going to the rabbi to convert to Judaism. You have to do it 3 times.
Yeah.
3 times the charm.
Yeah, that's how it works.
So
the rabbi has to say no.
Okay.
So to answer Member Kanada's question, why not reintroduce this again?
Right. So the thing is if you're concerned about the voting threshold with regards to this, I think it would have to be heard before a court. I think a court would have to make a final determination as to what the status of the Sunshine Ordinance Task Force is at this time, or put something on the ballot to change it, which is in process. They're all pretty much every single former chair of the task force is involved in creating new amendments.
Is there any update on what ballot that might make it to? We missed this year, right?
The only update I can give you, Right, trying for June. But know that there's also going to be an state election in March. They moved the primary.
Oh, that's right.
They moved the primary in March, so that actually can count as something to. Yeah, Member Eldon.
Get a chance to talk to the ethics commissioners more about how they view us.
No. I did speak to Chair Peter Keene a while ago, but it wasn't necessarily on that subject. But my sense from talking to their staff is they see us as being independent, and the only involvement is where they have jurisdiction. So they have jurisdiction to hear sunshine complaints on their own if somebody brings it to them directly. Which means that we wouldn't necessarily hear them, or we could, and the public is actually trying to create either confirmation or discrepancy, or in the case of 6734 with regards to willful failure, that's why there's a separate set of rules. I do have some concerns about that because of the way it didn't get finalized until I was already out, and it ended up not being what we had originally agreed to. So I do have some concerns. We should discuss that at a future meeting. It'll be a pretty lengthy discussion because we'll have to read through those rules.
I think they had someone came on board, I'm blanking on his name, who tried to revamp all that from the ethics side and worked with us closely. This is about 3 years ago.
Yeah, so that was before the new staff.
Yeah.
So we have there's new staff at ethics that are pretty good. They're very competent. They're very much public servants. There's no funny business going on that there had been for many years. So, but I think we should review it first. I would maybe suggest that we, have it in a committee, or we could do it as a committee of a whole, and everybody can show up on that day, on that committee day, and we can do it that way. But
any feedback from last month's meeting, aside from lack of members, on that ethics commission item?
Not that I've heard.
Not that you've.
No. Yeah, you should speak in the microphone, though.
Or not. Or not.
You will or not? You won't. Okay. All right. Because I'd like to get out of here soon. All right. Call the next item.
Public comment?
Oh, public comment. Yeah.
Tom. Is that his name? Tom?
You're definitely formed under charter law and subject to charter law. You're not formed to general law. If you were formed under general law, you would have either police or taxing power, and you would have to undergo the LAFCO process. You are definitely formed under charter law, and the reason why I know that is there is a very, very detailed city attorney memo regarding the controller's ability to curtail warrants for the school district. And it goes back to the 30s. There was a lawsuit in the 70s. There was a lawsuit in the 80s, all about whether the school district is formed under the charter or under general law. And it's very, very clear about what is and what isn't. So everything that comes from the charter inherits sunshine. That's why the school district is under the general law, but you're definitely under charter law. And the county office, no one will tell me.
Yeah, but where can we find that? I mean, where's the opinion of that?
You can't trust the city attorney, to be honest. It's a 1990 memo that related to the controller's ability to curtail warrants of the school district is very, very clear about understanding the difference between charter law and general law. Basically, charter law alters any Article 3 constitutional office to local control, or anything that is created through a local proposition will inherit from charter law because it's created under charter law, and it's.
Where's that? Where was that described so that they could come up with that memo? Where did they get the reference? Or did they pull it out of thin air, or is there some precedent, or is there some state law?
Basically, what would happen is the Board of Education would raise taxes too high, and the city said, no, we want to control the school district's budget. But then the question was, well, is the school district created under the charter because the old charter said that the school district was? It turns out that they said the school district is created under general law, and therefore you can do nothing about the school district if, say, they raise taxes too much. That was pre-Prop 13. Okay. So it's very, very clear the distinction between the two entities and what is charter, what is general.
Okay.
That's why the Public Utilities Commission is charter law, and you have jurisdiction there.
Yeah, but that's just an enterprise agency that was a nonprofit, more or less, for sake of a better term, it's a nonprofit created by the city.
Yes, because it was created by the city. It is not. It is created per the charter.
So you're saying the school district was not created by the city?
The school district was formed by the state.
Got it. Okay. Thank you.
What was your last name? You're like so smart.
Spell it.
I want to know who you are.
Bussy. B as in boy, U as umbrella, S as in Sierra, Edward.
USSE.
Yeah, but the superintendent of schools, I'm trying to figure out whether he's part of the county office or the school district, because this county office, I think, is chartered, and I think that's how they're getting the money back from the school district to the city. I can't tell.
Well, we had an interesting case regarding a very, very old body that's a joint body between. Is that? Oh, that was.
That's my case.
I'm sorry. That's where I recognize you from. Okay. Okay.
Wait,
great.
you're a singer, aren't you? That's
Yes.
that's where I know you.
Singer and music critic.
That's where I know you.
Okay. Next item.
Item 15, Administrator's Report, Complaints and Communications. I have a list of the next set of hearings. I believe that we have rescheduled one of the meetings listed.
Yep.
The November 13 meeting of the Compliance Amendments Committee has been rescheduled to November 13th to avoid the holidays. And I believe that the December 26th meeting of the Complaint Committee will be canceled.
I mean, I didn't say that, but okay.
The day after Christmas?
Sure.
It doesn't bother me.
Yeah, I'm sorry.
And I'm Jewish, so I'll come on Christmas. I fill in.
Thank you.
Okay. I have a list of the new complaints filed this month. It looks like there's about 9 new ones. We have a pending complaint total, pending hearing at both committee and the task force level of 45, which is an increase of 5 from the last month.
How many just
Yeah. and then-
I don't have that breakdown,
Oh, okay.
but I would say we have about 10 to 15 items pending at the full task force after today.
If you could include the breakdown in your future reports, that might be it. That might be helpful if you can easily.
Okay. And that completes my report.
Okay. Call next. Any questions for the administrator? Any public comment for the administrator? Okay. Great. Call next item.
Item 16, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Microphone.
I will be absent for the next full task force meeting. I just want to make that known just ahead of time. People are, because of quorum issues.
Yep.
So
Thank you.
We'll miss you terribly.
I'll miss you all too.
Actually, we will miss you. You have a lot of the legal knowledge that many of us do not have, so we really will miss you a lot.
Okay. Anybody else? All right. So I've got a few.
I'm
Okay, go
sorry.
ahead, Member Moss.
So October 19th is the California Data Demo Day in Sacramento. It is a morning of various parties talking to legislators and state staff about open data guidelines and why open data is awesome and open data this and open data that. If anybody happens to be in Sacramento on October 19th,
I will be in Sacramento.
feel free to stop by.
My own
I will be there in my professional capacity.
Where is it?
In Sacramento.
I don't know. Do you have a location?
I don't think
I'll
you
be
really
in the
want.
convention center, so if you're there, maybe I will sneak in.
I can send details
Thank
to.
you.
I don't think he
to
really wants
Victor
you
to
there. He's not
circulate.
telling you where it is.
I got an email for it. I'm like, why are you inviting me to this?
You're on the
When I got
task
this
force.
whole big email saying, come.
Okay.
I love open
A
data.
couple of things for the good of the cause. Speaking of open data, I happened to meet the new Chief Digital Services Officer. Her name is Carrie Bishop. She has a huge charge and role. She runs a big department now. She answers to the city administrator, basically revamping almost everybody's website and all the platforms that are in the city to make them user-friendly and whatnot. So I had spoken to her. We have a meeting set up for coffee just to kind of put together an agenda. She'll come and happy to present and take questions from us with regards to all that. Member Eldon.
Does her job fit in with Coit and with
She totally with Coit.
Nath?
Yeah, so not so much. She's not so much with Jay Nath because she's under the city administrator. Jay Nath is just kind of pulls all this together, but definitely with Coit because that's where you get all the department heads in the same room, and they're dealing with all the data information. So very smart. She's very approachable. She comes from her. She brings all her knowledge from the work they've done in London, and and it's impressive, some of the stuff that she talked about. 2, there's a new website called index.sfgov.org. That is the official index to records, okay, for the entire city. I urge you to review it and look at it. There's a requirement in the Sunshine Ordinance for every department to have an index of records. I looked at it. I do not think it's well organized. I still think it's a work in progress. So if you have any suggestions, bring them forward, and we'll get the person responsible for that in. We can have a conversation with them about that. I would ask Victor, if you would, when you call for the votes, and I hope this doesn't mess you up too much, to call the maker and the seconder of the motion first, because we know that their votes are going to have to be in the positive because they made the motion. Okay? I think it's appropriate that they be called first in the order. You can flip around the order thereafter, and then the chair last.
Yes.
Okay? If it's too much trouble, it starts driving you nuts, let me know.
We'll give it a try.
We'll give it a try. Okay. Behested payments. Okay, something that we've heard before. If you remember, Lee Hepner, former member of this task force, came in with that. That was an ordinance that was passed by. That was introduced by Aaron Peskin, Supervisor Aaron Peskin, was passed by the supervisors, goes into effect in 2018. We all have some way, shape, or form or another, may be involved or affected by it. There's still a ton of questions about it, how it applies to volunteer public officials versus, elected or paid or what have you. So Member Moss has a lot of questions that came from his organization. I have a lot of questions. I have 2 organizations that are concerned about this. We've asked DCA COLA to create, research it and create some guidelines because we may or may not be affected by it. It depends. I think, sorry?
Status of what's...
It goes into effect in 2018.
Oh, so it passed.
It passed, yes.
Oh, okay.
All right. So, this involves knowing about fundraising activities. If you're of a nonprofit, you may be on the board, a staffer, or on the board of directors of your organization. And there's all kinds of other provisions in it. But we'll go over it in more detail. I don't want to get into a lengthy conversation about it right now. Just wanted you to be aware of it. And I think something else that came up today that I think was important was that when documents are requested by a member of the public or whoever, because elected officials can use the Sunshine Ordinance too, that the respondent, if they provide attachments, should make those attachments part of the record. Because we see them in emails as, oh, there's the attachment. We don't really know what's in it. Okay, we don't even know if it's responsive. So instead of making that the burden of the petitioner, the complainant, or the requester, it should be the burden of the respondent. So let's make sure, those of you hearing complaints, chairs, to make sure that if attachments are part of that case, make sure they get printed out and sent in.
So it's okay if they provide a link, but when it comes to there's a complaint, we need to be able to see what was received or not received.
Right,
Okay.
exactly. And the problem also with links, they can change.
Yeah.
Yeah.
They can-
I mean,
You know?
links are okay if it's a voluminous thing and it's the best way to provide it is through FTP if you want it electronic, but I understand that if we're trying to adjudicate a matter, we need to be able to see what actually came.
Right, exactly. Okay, and that's all I got. Okay. Move to adjourn? Second. Moved by Hensey, second by Highland. We are by rising vote.
Thank you, Victor. Thank you, Victor.